Hello. The
Yes, sir.
danger is our earth survives on the sea. So if you offer the
Okay.
seas, you offer the earth.
Okay.
And once the earth, if
But
the
she,
earth is 75% water and you are offering that out, what are you left with?
okay, who gave us that answer? Please, can you provide Mr. Bako with, can you answer his question? Because she actually said that in her area, they don't have sea and they are surviving. So who provided that answer? Please, can you answer Mr. Bako's question?
Me. It's me. Like I said earlier,
Yes.
where
Yes.
I live, we don't have sea, and we are still surviving. There are people that live in drought area, in the far north. They don't have sea, and they are still living. And so that was why I said I was going to offer them the sea.
Okay, you are saying you are saying you offer them the sea. There are people who live on the sea and their livelihood is on the sea, just like you live in the north. So they cannot survive without the sea. So what do you think those people will be taken away? Because just as we live in the south, in the north, where there's plenty land, no water, that is hard too. We in the south, we live on top of the water. In fact, water is our means of livelihood. So what do you think will happen to the people that live there?
Okay, let me make an attempt. Hello? Hello?
Yes, sir. Please go ahead. Yes.
Yeah, my attempt is, since they want to take away, and we have a lot of wild animals that may not be too important to man, then I would say let them take wild animals off the earth and let them go their way. Is that a good offer?
So it depends on the aliens anyway. if they'll accept your wild animals.
It depends on them.
Yes, it depends on them. So who wants to act as the shit.
This is another serious one.
Who wants to offer as an alien to represent the alien community? Then Mr. Bakona is representing Earth, so that you both can now negotiate, and then we'll see if the alien community will accept Mr. Bako's request, the alien spaceship. Okay, I can see Jane Marine's hand up. Please, you want to say something before we commence, before we continue? Jane Marine.
Let me bring it.
Jane Maria, or it's not to say, sorry. Okay, if he's not saying something, please, who is representing Earth? Oh, Mr. Baku is representing Earth. Who is representing the alien species? Any volunteer? Jane Marie, you want to volunteer? Hello? Hello? Okay, we have, let me just call. Madam Kushi. Can you hear me? Am I audible?
Yes. Yeah, the thing is on and off. It's on and off. Hello? Hello?
Okay, sorry, my network logged me out. Let me still share my screen. Okay. Please go ahead. Who is representing the alien species? Mr. Bakwas, are you still here with us? Okay, I can see Madam Egodo Blessing. Good morning to you, ma'am. You are muted.
Good morning, ma'am.
Kindly unmute. Yeah. You get the check-in activity. Yes, yes. You get the check-in.
Hello. You said,
Yes,
imagine you have.
Are you just logging in or you are part of the conversation? You have been part of the conversation.
I'll be part of the conversation.
Okay, so do you want to represent the alien species?
Yes, I want to represent the area species.
All right. Mr. Bako, are you here? Mr. Bako? Okay, who actually said you offer the alien the sea?
I'm the one.
We have who, please?
I'm the one. Pushing.
Okay, Madam Pushing. So I want you to negotiate with Madam Egodo Blessing. You said you offer her the sea and you give her the reasons why. So let me test your negotiation skills. Please go ahead.
Hello?
Hello.
Good morning.
Good morning. Yes.
Good morning.
Yes. For me,
Good morning.
to live Earth, surviving.
Alien.
There's something you have to
Ma?
something credible.
Hello?
You have to give me something that is cultural to the. Hello? Can you
Yes,
hear
we
me?
can hear you.
Yes.
Hello?
Can you hear me?
Hello? Yes.
Hello?
I
Yes,
can
we can hear you.
So what do you say you can offer me? You say you can offer me what?
I will like to offer you the sea.
But this is not palatable with me.
Yeah, I think you will like it because we have some animals in it. We have some animals in it. We have the fish, we have crocodiles, we have snails, we have crabs, we have crayfish. We have a lot of things that you will love. That's what I'm offering
if
you.
I go with
the
sea, then the earth will not be existing because the earth is actually hung upon the sea. You know that?
Okay.
Hello?
I'm not too convinced about that. But I'm offering the sea because presently where I live, I survive without it. And I think that it's something that if I don't have, it will not really affect my existence.
But do you know that there are people that live on the sea, just as we live in the north? Is that will that not be self-centeredness? So you have not been to the side of where you see people living on the sea. People actually live. There are activities going on in the sea. There are people that live on top of the sea. There are islands. So what do you think will happen to those people?
It's because I'm considering my interests and what affects me. Because I don't live there, I've not seen people live in the sea. So I'm considering my own interests.
But what if I tell you I have something in mind that I want from you? Hello?
Please, can I hear it? Can I hear it?
What if I want something, there's something particular I want from you. Can you give it to me?
Say it, let me hear. If it's something I can forfeit, I will do
I
so.
want the political class of earth. The political class of the
Political class.
earth. Yes. Yes.
I'll give it to you wholeheartedly.
Do you
I'll
know
give it
why
to
don't
you.
you ask why the political class of the earth?
No. I don't need your information.
Thank you so much,
I don't want to
Madam
know why
Seidu
you
and Madam
need
Blessing.
it.
Can you hear me?
Thank you, ma.
Hello.
Thank you, ma.
Hello?
Can we say, yes, can we say Madam Blessing is a good negotiator?
Hello?
Madam Egodo Blessing, can you hear me? Will you say you are a good negotiator?
I can hear you.
Yes. Can you assess yourself? Will you say you are a good
Yeah, because
negotiator?
I want, I think I do, because the question that's why I asked, why don't you ask why I wanted a political class? Hello?
Okay, she didn't ask you. She didn't ask why you wanted the political class, right?
I said that I don't need her to give me any reason. I will wholeheartedly give it to her.
That is very dangerous.
Okay.
Mr. Babu, we have been waiting for you.
Sorry, I had the request is a dangerous one, because if the aliens is political club, we use whatever.
Yes. Okay, one person should speak at a time so we can hear.
Yes, I think why I really wanted the political class, because it's called the political class all over the world. They are unique, having problems. There's no peace in the world. Remove them, let's start all over, like the Lord of the Flies. So let's start all over and see where we get to. Because all the political people in the world, they have problems.
Okay. So, Mr. Bako.
Yes, madam. I wish to
Okay,
continue.
And let me share who wants to volunteer. You are now representing Earth, right?
Okay, I'm representing.
Okay, just to make a comment on that of Mrs. Egodo Blessing and Saidu. You say you want to offer them political class because we have been having issues. The political class have been giving us issues all over the world, like you said. So do you think the aliens will accept that?
No, I wouldn't just offer them, but I have to ask, especially going by some of the principles we've talked about.
Yes.
The way by the student's position, we should try to find out their interest, because that is going to be a better way to broker a resolution.
Okay.
We want to find out the aliens, if they want, what exactly are they going to do? Because it's easy to give them up and they bring to torment the rest of the people on earth. So why really do you want? So that would be the first thing I want to do before I begin to think of drawing a
Okay. So let's get to hear you, Mr. Bako, and someone else negotiate. Right? Is that okay?
It's okay. Let's see if we can do that quickly.
Okay, so briefly, who wants to volunteer to represent the alien species?
Okay, I will represent the alien species.
Just call a name because our facilitator this morning has joined the meeting. So
I will represent the alien species.
who is speaking?
Amoluwatosin. I will represent the alien species. Amoluwatosin.
All right, go ahead. All right, go ahead, please. You just have 1 minute to negotiate.
So they are the one coming.
Hello, the head. Yes. Hello, the head. Hello, the head. We, the alien species, we want.
Good morning.
Hello, the head. Good morning. As we have discussed with you earlier, we, the alien species, we want something cultural from the head for survival. So what are you offering us?
I mean, what are the things away from the earth that survive?
Like I said, we want something that represents the earth culture. We want something that represents the culture, the tradition of the earth. So out of all these things that you have, I know you have a lot of things on earth. So many big, beautiful things that represent culture and traditions. Which of it are you ready to let go?
You are not making a choice, and you are not in the wild animals out of the earth and the survival.
No, the earth, I won't accept wild animals. Wild animals to us alien does not represent a culture and tradition on the earth. They are creatures, they are there for a reason. So convince me that I said we the aliens are not going to accept wild animals as we are not going to accept wild animals as something that represents culture and tradition on earth. We want something that represents culture on earth.
The truth is, like you began, anything of the arts culture, and whatever we offer you is something that has something to give. So if you are using that as a reason to reject the wild animals, whatever else we would offer has a benefit to the earth. So that is not a good reason to reject the wild animals, except if you want to make it.
Me that the wild animals represent culture on earth.
Yeah, they do of the earth, and they are part of the creatures of the earth. So they are part of the earth culture, except if you define what you understand by earth culture and give me options of things you want.
Yes, like I said, there are so many beautiful things that represent culture and tradition on earth. We have food. We have food eaten by people that represent where they come from and what they believe in. We have the way people dress. We have people celebrating different festivals to represent culture. So we have good examples of things, beautiful things that represent earth culture that we want, not wild animals.
Okay, we're rounding off. Mr. Bako, you don't have anything else to offer?
You want to take the wild animals? Let me. Okay,
yes, would
you want to take the desert?
Yes, we can take the desert if you can convince me that desert represents the earth culture.
Yeah, the desert is part of the art culture. I know people survive there, but we can forfeit that for you and see how they will relocate valuable areas.
So thank you so much. I think we'll close this session now. You said you offer her the desert.
Yeah.
Okay, she's demanding for the desert, and then we can actually offer the desert. So I think that will suffice.
Yeah, thank you, madam.
All right.
So let's get on our presentation. Thank you.
You're welcome. So we're having Mr. Joseph George, who will be taking us on ethics in mediation this morning. I'll just briefly read about him. Can you all see my screen? Can you confirm if you can see my screen?
Yes, you can.
Okay, so
the screen is clear.
Okay, Mr. Joseph George is part of our faculty member. He's a certified international mediator and arbitrator. Please, can you mute if you are not speaking? Yourself. He's a hostage negotiator under George and George Adel Group, Florida, USA. Mr. Joseph George is the founder of George and George, like I rightly said. He is a distinguished entrepreneur and an expert in alternative dispute resolution with a deep commitment to fairness and efficiency. As a Florida Supreme Court certified county mediator and qualified arbitrator, Joseph excels in guiding parties through complex business, construction, and employment disputes. Okay, so his unique expertise as a certified and trained state negotiator has a critical edge to his ability to handle high pressure situation and crisis management. Without wasting of much time, Mr. Joseph George, you're welcome. Please go ahead. Thank you so much.
Good morning, everyone. It's a pleasure to be here. It's morning where I'm at. It's after 5 o'clock.
Good morning, sir.
And I'm going to be taking you to a journey through the ethical process of mediation. Can we go ahead and share my screen?
Okay. Let me see.
I'm going to be using the Florida courts ethics rules. And the reason why I'm using that one, there's many out there. The reason I'm using the Florida one is because their standard is extremely higher than mostly everybody else. And they're very efficient in the way that they do things. There's other courts that have similar, but most courts and most other organizations template off of the Florida Supreme Court ethics standards because it's that high, and it just sets the bar so high for everybody else. Nobody really could touch the Florida Supreme Court's ethics. And they also make changes every so often with their MECA opinions and things like that, just to make sure that they're moving with the times of evolution, to make sure that the mediation and arbitration practice is adhered to, and there's standards that should be followed by the mediator or arbitrators. Okay, so let's see if I could share my screen here. I think you have to stop sharing your screen so I could share my screen.
All right, sir.
Let me go ahead say where you stopped the screen sharing. Do you want to continue? Yes. Okay, let's see, where do I have mine?
Okay, you can go ahead to share the screen. It will replace mine. I've made you
Okay.
a co-host.
I'm going through now.
Made you a co-host, rather.
Okay, can everyone see that?
Yes, sir.
Okay. So the reason why we have ethics and standards for mediation is because we want to make sure that everybody follow the rules. If we don't have rules, we have chaos. So we want to make sure that the standard of mediation is adhered to by everyone and it's universal. And just to make sure that nobody doesn't go off script in mediation and create problems that they don't need to create for themselves, as well as for the attorneys, for the parties, for the proceeds. We want to make sure that we have a standard that goes throughout everybody. So I'm going to read a couple and then I'll explain as I go through some of them. The committee notes, I'm not really going to talk too much about committee notes, but the committee notes show you the relevance of how serious the Florida Supreme Court standard is, that they have a committee to manage the rules and make changes as need be. So it says, so rule 10.200, the scope and process. These rules provide ethical standards of conduct for certified and court-appointed mediators. The court-appointed mediators are mediators selected by the parties or appointed by the court as the mediators in court or mediation. These rules are intended to both guide mediators in the performance of their service and skills and instill public confidence in mediation process. So what they're saying is that they want to make sure that the ethical standards of mediation, when we're dealing with the public, we want to make sure that we are professionals in the process and we're guiding the process to a reasonable and a balanced process without disrupting the process of trying to seem like we're taking sides. The public's use and understanding and satisfaction with mediation can only be achieved if mediators embrace the highest ethical principles. Whether the parties involved in mediation choose to resolve their dispute in secondary in importance to whether the mediator conducts the mediation in accordance with these ethical standards. The committee notes will tell you it's been revised in 2000 revision, but in the early 1991, the Florida Supreme Court Standing Committee on Mediation and Arbitration Rules was commissioned by the Chief Justice to research and draft and present for adoption both a comprehensive set of ethical standards for the Florida mediators and the procedure rules for their enforcement. To accomplish this task, the committee divided itself into two subcommittees and over the remainder of the year launched parallel programs to research and develop the requested ethical standards in grievance procedures. So they have two committees that actually make sure that the ethical standards is adhered to. So that's why I said I want to make sure that I teach you off of the Florida Supreme Court rules, because their standard is so high that teaching you this is going to put you above any other university or organization that teaches mediation. So it puts you a little bit ahead. So we can skip all that because all that is just more of what they're about. We can continue to go to the rules. So mediation defined. Mediation is a process whereby a neutral, impartial third person acts to encourage and facilitate the resolution of a dispute without prescribing what it should be. It is an informal and non-adversarial process intended to help disputing parties reach a mutual acceptable agreement. So you guys already know what mediation is. You guys have learned this over and over. But I'm going to just throw in something there on my own. I always say, be professional even when others aren't professional. And with saying that, that means if somebody's arguing at you in mediation, just say, sir or ma'am, I understand your concerns, I understand your feelings, but we're in mediation. Can you please calm down? Or, ask them to be a little more forthcoming in the process and trust the process. It will take you through and help you resolve your dispute. And most of the time that usually works. If you have somebody who does not want to resolve their dispute and they just want to go to the courthouse, no matter what you say, you're not going to change their mind. But sometimes just talking to them privately and explaining to them the process of mediation actually helps to bring them down. And if you tell them that, if you go in front of the judge, sometimes the judge is the one who's making the rule. Versus in mediation, they have the opportunity to kind of assist in drafting their own mediation resolution that they could benefit from versus going to the courthouse. Okay? So in Rule 10.220, it says the rule of the mediator is to reduce obstacles to communicate, assist in the identification of issues and exploration of alternatives, and otherwise facilitate voluntary agreement, resolving the dispute. The ultimate decision-making authority, however, rests solely with the parties. So what that rule is telling you is that you're only going to assist the both parties in resolving their dispute. You're not the one that's going to make the determination on how the dispute resolve, but you're going to assist them in coming up with options and better strategies to resolve the dispute. I want to put insight in this one here also, just for your notes. When it comes in mediation, you're going to be dealing with attorneys also. And sometimes you have some attorneys, I like to say, have a strong personality. So with having a strong personality attorney, sometimes they also push issues and they're a little bit aggressive in mediation. So sometimes you will have to address that attorney if that attorney becomes disruptive in the process and they're actually making the process not work out as the intended purpose of what you are trying to address with both parties. So, but you don't address that attorney in the forum of which you are in a joint session. You will pull that attorney, sidebar him in a private room and have that private conversation with him and let that attorney, him or her, know that, hey, we're all here to resolve the dispute. Nobody really wants to go to court. We're here to address this dispute. And I know you're a little bit aggressive. I know you're passionate for fighting for your client. I understand that. But can we bring it down a couple notches so we can resolve this dispute today? Everybody is here in good faith. And usually once you tell the attorneys that, they usually calm down and they're usually going to come back into the session and they can help you to resolve the dispute. All attorneys know, doesn't matter what, well, here in the United States, I think over where everybody else is, nationwide or international, all attorneys have a governing body and they have their own ethical rules too. So even in mediation here in the States, all the governing bodies for attorneys have understand what mediation process is and have let attorneys know that even in mediation, they have to conduct themselves in the appropriate manner. Okay, so let's move on to Rule 10.230, the mediation concept. Mediation is based on the concept of communication, negotiation, facilitation, and problem solving that emphasizing self-determination. B, the need and the interest of the parties. C, fairness. D, procedural flexibility. E, confidentiality. And F, full disclosure. So, when we do our opening statements, we always have to, here in Florida, we always have to express that mediation is a confidential. This is the part in Florida that's required to put in your opening statement, and it usually says mediation is a confidential process, and you let them know mediation is confidential process, except where disclosure is required or permitted by law. We have to put that in our opening statement. And the reason we put that in is if somebody says, hey, I'm going to go and harm somebody else, then that breaks the confidentiality because you have to alert the authorities that this person has threatened harm to someone else. So you have to, so in mediation, that's the only spot that's not confidential. So if you feel that you're going to be harmed or this person is seriously willing to harm another person or the other party in the mediation process, then you have full authority to break confidentiality to call the proper authorities and say, hey, this person's either going to harm themselves or they're going to harm someone else. So that's the only time that you break confidentiality. The second part in breaking confidentiality is if you ask both parties because you have to address a third party outside of mediation, then you have to get all parties involved to say, hey, I need to seek counsel about this particular part that I don't understand, and I need to seek outside third party. Is both parties willing to release me from the confidentiality just to this particular party so I could get the answer to assist them in resolving the dispute. So as long as all parties agree to release you of that confidentiality just for that specific part to aid them in resolving the dispute to a third party, then that's the secondary part then that you can release the confidentiality clause. So here we go to responsibility of the mediator's responsibility to the parties. And this is rule number 10.300. The purpose of mediation is to provide a forum for consensual dispute resolution by the parties. It is not the adjudicatory procedure. Accordingly, a mediator responsibility to the parties includes honing their rights of self-determination, acting with impartiality, and avoiding cohesion, improper influence, and conflict of interest. A mediator is also responsible for maintaining an appropriate demeanor and preserving confidentiality and promoting the awareness by the parties of the interests of a non-participating person. A mediator business practice should reflect fairness, integrity, and impartiality. So that rule right there alone, rule 10.300, that rule alone is, if you open up your own practice, that you have to take that with you. So that is like, I call it the heartbeat of the ethics right there, is rule 10.300. I call that the heartbeat. Because in mediation, you don't want to seem like you're taking over one person's side and coercing them into something else. You want to remain impartial and you want to remain fair. And if you're going to do something with one, you have to do to the other. And then you want to be, I always say clarity. I have clarity with both parties when I'm mediating. So I always tell them, hey, listen, I'm going to let the other side know this if you okay. And in mediation, you have to that's where the confidentiality is coming, where it says preserving confidentiality. Well, it's not just preserving it outside of the mediation, it's preserving it inside mediation process. So when you go into joint sessions and you're talking to one party, before you go to the other person and talk to the other party, you have to ask that particular party, hey, is there anything that you don't want me to let the other side know? And if they say, well, don't let them know this part till the end, then you have to hold that information to yourself until the other party gives you the opportunity to now share that information with the other side. So confidentiality is not outside of mediation also, but confidentiality is within the mediation process as you're trying to assist both parties in resolving the dispute. So it's very critical that you try not to say something. I've seen other mediators where they take information from one party to the next, and then they come back and themselves like, I didn't want them to know that. Because the person didn't say, hey, I want this to remain confidential, doesn't mean that they want it to be disclosed. So that's why it's very important when you're in separate rooms or caucus, you always want to make sure you ask, hey, is there anything that you want me not to take to the other side, that you want to remain confidential to this process here with us before I go and talk to the other party? Because you sometimes you could escalate that situation and lit the match to cause the situation to get a little bit chaotic. But if you're good at what you're doing and communicating very well in mediation, then you could kind of bring them back on track, even if it's something that happened. I call it innocent error. You could kind of bring them back on track. And as a business, you always want to remain fair, and you want to keep that integrity intact. Because remember, this is a professional business that we're in, and even though we're mediators, we're still in the legal field. I know a lot of people always feel like we're not in the legal field, but we are mediators, we are in the legal field. So we have to protect this industry that's, I don't know if you noticed, but this industry is evolving very quickly. Even AI is catching up to us right now. So we want to protect the integrity of the mediation and arbitration also. We want to protect those two industries. So for lifetime to come, it's still clean and a fair practice that the public would rather choose than litigation. So let's move on to Rule 10, 310, self-determination. Decision making. Decision made during a mediation are to be made by the parties. That's where we go back. In mediation, we are mediators. We assist parties in resolving the dispute. We are not the ones that make up the decision and say, this is the decision that I think that is best for both parties. We can go with that, and I'm going to draft up a stipulation and agreement, and we're going to bound you guys to it. No, the decision in mediation is made by both parties. We assist them in the process of making that decision. We give them the knowledge that we know, and then just sometimes you could say, hey, can you try this? What if you think if you try this? So you could give suggestive things to them and let them figure out that on their own. But it's our job to assist them, not to make the decision for them. A mediator shall not make some substantive any party. Hello? A mediator is responsible for assisting the parties in reaching a formal and voluntary decision while protecting their rights of self-determination. Coercion prohibited. So that's what we're talking about. Coercion is prohibited, meaning that you don't want to coerce anybody into something that you feel is beneficial for them. That is prohibited. That right there is going to get you in trouble. And I think that goes across the board in any organization. You're not there to coerce them into anything. So coercion is definitely prohibited. A mediator shall not coerce or improperly influence any party to make a decision or unwillingly participate in a mediation. Mediation is a choice. So if one party does not want to participate in mediation, your job is to force them into mediating. If they say, hey, you know what, I don't want to mediate anymore, you just say, okay, we're just going to call this an impasse. And you let both parties know the other side does not want to mediate anymore. That's their choice. If they want to back out, that's their choice. It's not our job to enforce mediation on them. Misrepresentation prohibited. A mediator shall not intentionally or knowingly misrepresent any material facts or circumstances in the course of conducting a mediation. So what that means is you don't want to kind of take something small and create a fantasy around that material to kind of get to sway the other side to cave in or to accept something that was wrongfully not there. They need the straight facts of whatever material there is. You can help them understand the material. If they don't understand, you could assist them in understanding what the material is. But keep in mind, you don't want to tread too deep in where you're actually giving advice. That's for attorneys. And in mediation, we're not attorneys, we are mediators. Even if you're an attorney, again, in mediation, Once mediation starts, you're no longer an attorney. You are a mediator. So you want to make sure that when you have materials in front of you, you want to give them the facts straight off as you see it on that document, or whatever evidence was presented to you, or whatever facts was said to you by the opposing party. You want to make sure that you lay the information as truthfully and honestly as you can be. Don't misrepresent any particular stuff, because it would shift the way the mediation process is. Okay, postponement or cancellation. If for any reason a party is unable to freely exercise self-determination, a mediator shall cancel or postpone the mediation. So if a person cannot make it to the mediation, or they feel like they need more time, or unable to freely exercise their self for whatever reason, or they feel and that's usually happening with a lot of proceeds. When you have proceeds who's representing themselves, and they don't have attorney, sometimes they get into mediation and then realize that they may need assistance. They're the ones who would freely want to back out of the mediation, and it's fine. It happens. Just let them cancel it, and set up a new scheduled time, where both parties can actually do it, or where they have representation. Let's move on. It say, that's from the notes. Rule 10.320, non-participating persons. I've had this many times. I've had where this is the part I always have to address, because you're gonna see it all the time. And it's usually with the proceeds. It's never really with the attorneys. The attorneys usually let everybody know who's attending the mediation. Sometimes they send you an email and they say, hey, I have a colleague that's gonna be attending mediation. Same as mediators. We as mediators, we may have another mediator who wants to observe. They're a little bit, they just get the certification, and they want to observe a particular mediator, just to see how the process goes. Sometimes you have a judge who would like to get in, judge or anybody just wants to get in and observe the mediation. But with proceeds, it's very big. They want to have their mom, their dad, best friend, co-worker, and they don't send you out any information that this person that person can't be in mediation. That's between them and the parties. So that's where non-participating persons have to make awareness of that particular person being there in mediation. And sometimes they'll have the person off camera, and you'll pick up on it where you see the person talking to somebody. And I've seen that several times, and I say, excuse me, do you have somebody in the room with you? And they say, yes, I have my mom. She's sitting here as my support. And I will tell them, well, let me find out from the other party if they fine with her sitting in with you. If the other party agree to it, it's fine. If the other person says, no, I don't want that person sitting in on the mediation, it's supposed to be confidential, they did not let us know, then you have to go and tell them, hey, that person needs to leave the room. If they're not going to let the person leave the room, and that you might have to just go ahead and cancel the mediation. Just because if the both parties is not going to agree to that one person being there, it don't make sense to continue with the mediation, because they're not going to continue with that person being there. So I'll read out what 10.320 says for non-participating person. A mediator shall promote awareness by the parties of the interests of persons affected by actual or potentially agreements who are not represented at mediation. And then again, I can read committee notes here, because sometimes the committee notes give you a little deeper understanding of why they made that rule. So it was revised in 2000, and it says mediating agreements will often impact persons or entities not participating in the process. Example includes lien holders, government agencies, shareholders, and related commercial entities. In family and dependency mediation, the interest of a child of children, grandparents, or other related persons are also often affected. A mediator is responsible for making the parties aware of the potential interests of such non-participating person. In raising awareness of an interest of a non-participating person, however, the mediator shall still respect the rights of the parties to make their own decision. Further raising awareness of possible interests of related entities shall not involve advocacy or judgment as to the merits of those interests. In family mediation, for example, a mediator shall make the parents aware of the children's interests without interfering with self-determination or advocating a particular position. If you're not talking, can you please mute your mic, please?
Immigration.
Miss Miriam, can you mute my please? Thank you. Rule 10.330, impartiality. Generally, a mediator shall maintain impartiality throughout the mediation process. Impartiality means freedom from favoritism and bias in word, action, appearance, included a commitment to assist all parties as opposed to any one individual. So what they're saying inside here is pretty much don't take sides. I'm just going to give it to you straight, lenient terms, simple. Don't take sides. Don't go into mediation and because you see somebody wearing something that you don't like and you immediately cast judgment on them immediately. You go in mediation and you treat everybody like it's like they're your teammates, they're on your team. Treat both parties like that. Just go in there, try to figure out what the problem is and how can you assist them in resolving it. So I always like to say the meat and potatoes. Figure out what the meat and potatoes is of the situation, and then go in there and resolve it for both parties. Withdrawals of partiality. Immediate shall withdraw from mediation if the mediator is no longer impartial. So if you cannot remain biased, if you cannot be impartial of the parties, then just go ahead and withdraw from the mediation process. So in the high steam of I'm gonna put it out there. I like to be blunt. In racism, let's use racism. If you find somebody in mediation as racist and you can't remain impartial, just stop the mediation and don't continue any further. You know, just shut it down and just move on. Just apologize to parties and say, listen, I think this is a conflict of interest for me. I could no longer continue with the mediation process. And that's how you go about doing that. Because if you're not going to be impartial, then you're going to just get yourself into some trouble. If you have a governing body, like we have a governing body, and they file a complaint on you, you have to go before that governing body and explain to them what happened in mediation. And you don't want that. So if you're not going to be impartial, just go ahead and just withdraw from the process. Here we go. So we got C, gift and solicitation. A mediator shall neither give nor accept a gift, favor, loan, or other items of value in any mediation process. During the mediation process, the mediator shall not solicit or otherwise attempt to procure future professional service. I've seen this only but one time in doing mediation where I saw a mediator. I was observing him and he was letting the attorney know, hey, I offer notary services and all, you know, he was explaining other stuff that he had. There's a time and place for everything, and mediation is not the time and place for that. Mediation is a time and place for assisting parties in resolving dispute, not for you to promote yourself. If you want to promote yourself, you do that outside of the mediation process. Now, if the attorney asks you something, let the attorney ask you. You answering his question, but you don't go out there and do self-promotion. You don't go and volunteer information and say, hey, by the way, this is what I do also if you need so and so. Just go into mediation, resolve this, assist the parties in resolving the dispute, and move forward. And I'm gonna read a little bit of committee notes. That way the committee notes could do a little bit more clarification. A mediator has an affirmative obligation to maintain impartiality throughout the entire mediation process. The duty to maintain impartiality arises immediately upon learning of a potential engagement for providing mediation service. A mediator shall not accept or continue any engagement for mediation service in which the ability to maintain impartiality is reasonably impaired or compromised. And that's again, if you feel like you cannot be impartial to the parties, just leave the mediation. Just back out. It's just easier that way. And that's why I want to read that particular part. We can go down to conflict of interest, because the conflict of interest is one of this, I call it the secondary heartbeat of mediation, because a lot of people don't understand if there's a conflict of interest, it's best not to proceed with the mediation process, especially because when you go into separate rooms and then the mediation is over, and then the other part, one of the parties who felt they didn't get their just rights in mediation, they felt like they didn't get exactly what they wanted out of the mediation process. And that conflict of interest could come into play, and they may file a complaint against you. So Rule 10.340, conflict of interest. A, generally, a mediator shall not mediate a matter that presents a clear or undisclosed conflict of interest. A conflict of interest arises when any relationship between the mediator and the mediation participants of the subject matter or the dispute compromises or appears to compromise the mediator's impartiality. Burden of disclosure. The burden of disclosure of any potential conflict of interest rests on the mediator. So what I'm saying is, if you have to be able to disclose it yourself, so you don't want to wait and say, hey, maybe they're going to find out later on. No, before you start the mediation process, and how I start the process, can you mute your mic if you're not talking, please? So disclosure rests on you. So when I go into mediation, and if I have an attorney that I've seen in the courthouse, or I mediated several times over with that particular attorney, I go into mediation and I say, before I get started, I'd like to let all parties know that this particular attorney, I know this attorney. We don't have drinks together. We don't sit down. We're not buddies. But because I've seen him several times, because I've mediated several cases with that first particular attorney. So you just let them know right off the back. And if they feel like it's going to be uncomfortable for them, then they would disclose that to you. But if it's somebody, say like a best friend, you go into mediation, say it's a best friend, they will say, hey, this person is a best friend. I've known him for X, Y, Z. But I could remain impartial. Me personally, I would see that as a conflict of interest, and I would back out of the mediation and tell them, I didn't know this person was coming into mediation. This person is a childhood friend. It's a conflict of interest for me. We're gonna have to reschedule a mediation with another mediator. And usually they're particularly fine. Sometimes I've had one party said, hey, if you could remain impartial, then we could go ahead with the mediation. And most of the time I'd say, yes, I could remain impartial, because I don't care who comes in front of me. If it's a friend, grandmother, or whoever, I'm looking at the issue at hand. I'm looking at their dispute and trying to assist them in how we can resolve their dispute together. So I could always remain impartial. Doesn't matter who's in front of me. I never take favoritism to anybody. So the burden of disclosure of any potential conflict of interest rests on the mediator. Disclosure shall be made as soon as, particularly after the mediator becomes aware of the interests of the relationship giving a rise to the potential conflict of interest. Effects of disclosure. After appropriate disclosure, the mediator may serve if all parties agree. See, that's what I'm saying. As long as the parties agree, you can continue. If you feel like it's not going to be compromised, you can still continue. But all parties have to agree to it. However, if the conflict of interest clearly impairs a mediator's impartiality, the mediator shall withdraw regardless of the express agreement of the parties. And that's the second part where I told you, depending on what it is, I would rather just remove myself because conflict of interest, depending if one party say, hey, I feel he favor in the other person's side. So I would just remove myself completely just to avoid being sanctioned. D, conflict during mediation. A mediator shall not create a conflict of interest during the mediation. During a mediation, a mediator shall not provide any service that are not directly related to the mediation process. Now, so in Florida we have what's called a MEC opinion. That's a separate organization of the dispute resolution process where they sit on questions. I call it gray areas of mediation, where we scratch our head like, is it okay for me to do this? So sometimes it'll be a rule and sometimes it will not be a rule. Like this right here is actually a rule. MECA opinions, they're saying, well, we feel you shouldn't do this, but it's not a rule. But be careful if you do it because it might create a problem. So always, again, I just stick to the rules and try to avoid all the gray areas as much as I can. Senior and retired judges. If a mediator who is a senior judge or retired judge not eligible for assignments to temporary judicial duty has presided over a case involving any party, attorney, or law firm in the mediation, the mediator shall disclose such facts prior to mediation. So that what's that saying? If you're a judge and you had a case and now that he's retired and now that case come back to him in mediation, he has to remove himself from that mediation process. So he knows that attorney and been presiding with that attorney over years, he have to disclose that information that he's worked with that attorney or he's worked with that law firm for a significant amount of time. He has to remove himself. A mediator shall not serve as a mediator in any case in a circuit in which the mediator is currently presided over civil cases as a senior judge. Absent express consent of the parties, and mediators shall not serve as a senior judge. So that's only for judges that have served over cases, because again, mediation has a lot of retired judges who do mediation. Over any case involving any party, attorney, or law firm that is utilized or utilizes the judge as a mediator within the provision of 3 years. A senior judge who provides mediation service may preside over a criminal case in circuits in which the judge provides mediation service. The senior judge who provides mediation service may also preside over civil and criminal cases in circuits in which the judge does not provide mediation service. So that goes to judge. And I wanted, that's why, this is the reason why I wanted to use the Florida Supreme Court rulings, because they capture everything. Because in teaching, they say, I don't know this curriculum to you guys. I don't know if there's retired judges, that I'm teaching to. I don't know if it's lawyers I'm teaching to. I don't know who I'm teaching to. So I like to make sure I give you as much information. That way, when you leave this training at this university, this facility, that you have all the information. And not only that, even if you're not a judge, you can share that information with somebody else. So, they always say knowledge is power. So the more the merrier. Rule 10350, demeanor. A mediator shall be patient, dignified, and courteous during the mediation process. And that means that you don't want to be slouching over like, oh man, I can't wait to this meeting. Oh, I'm tired of this guy. He's just ragging on. You got to, again, that comes to what I said when we first started. You got to be professional at all times, even when others are not. And that's where demeanor comes into play. Confidentiality again. So 10360 confidentiality. Its scope. So a mediator shall maintain confidentiality of all information revealed during mediation, except where disclosure is required or permitted by law or is agreed by all parties. Caucus. Information obtained during caucus may not be revealed by the mediator to any other mediation participant without the consent of the disclosing party. Remember, I just explained that to you guys earlier, that when you're in caucus, and I don't use the word caucus, I use joint sessions, or I use separate rooms, because if you have a proceed, they don't understand our legal language. So I would say in a separate room or session, but caucus is the main word, but that's more the legal terminology. So you don't want to, until the other party tells you, and again, I always say, I don't wait for them to tell me, I always ask. It's better safe than sorry. So I would say, is there anything in this meeting that you told me that you do not want the other side to know? And then if they say, no, I don't want them to know that I told you that I'm willing to spend to resolve this at $10,000. You know, don't tell them that. Just keep them thinking that I'm willing to resolve it for 4,000. So you'll go over and tell them, okay. And because you can remember in mediation, sometimes they'll be negotiating, and it depends on the case that is before you. But again, that's what in caucus, you don't, confidentiality comes into play. Record keeping. A mediator shall maintain confidentiality in the storage of disposal of records and shall not disclose of any identifying information when materials are used for research, training, or statistical comprehensions. So me, after mediation, I have a shredder and I shred my information. So I don't keep my information sitting at my house. I have a shredder and I shred the information. That's the best way to do it. I know I've seen mediators say, "Oh, I keep mine in a file cabinet," and I always wonder why. I mean, mediation is over. What you think you need it for? So I always shred my information. Now, here, this part right here, Rule 10370. This is the part that can get you into trouble. So this is the part that you want to keep in mind too. And I'm going to read some committee notes on this here, because I want you guys to fully understand that why this part can get you into some serious trouble. Because when you're mediating, you're not a lawyer. You cannot give advice. That's not what you're there for. You're there to assist both parties in resolving their dispute. So Rule 10370, advice, opinions, or information. Providing information, consent with standard or impartiality, and preserving parties' self-determination. A mediator may provide information that the mediator is qualified by training or experience to provide. So again, that's why it's always good to pick cases that you're trained upon. You don't want to pull things out of the sky or out of we call it out of the magic hat and say, I think this is going to work. No, if you're trained on something and you have the knowledge and expertise on it, then it's best to use that knowledge to assist the parties in resolving the dispute. But if you're not trained on something, it's best not to go into something that you're not trained on, because you're gonna give them bad information that is not gonna be useful to them, especially when they're gonna be signing agreements. So B, independent legal advice. When a mediator believes the party does not understand or appreciate how an agreement may adversely affect legal rights or obligations, the mediator shall advise the parties of their rights to seek independent legal counsel. That line alone tells you you're not an attorney. Have them provide a legal counsel. Even if you're even if you're attorney in mediation, again, the rules and the ethical rules state that when you're in mediation, you're a mediator. You're not attorney, you're not legal counsel. So you cannot provide legal counsel inside of mediation. You have to send them to somebody else outside legal counsel. And again, I'm going to read the footnotes on that from the committee just to get some clarity so you can understand for any attorney that's in this training class. Professional of profession opinion. A media shall not offer a professional or professional opinion intended to coerce the parties, unduly influence the parties, decide a dispute, or direct a resolution of any issue. Consent with standards of impartiality and preserving parties' self-determination. However, a media may point out possible outcomes of the case or dispute, the merits of a claim or defense. A media shall not offer a professional or a personal or professional opinion as to how the court in which the case has been filed will resolve the dispute. So what they're saying is, when you're talking to the parties, you don't want to be like, well, the judge, I've seen this 100 times where the judge has ruled in favor of so and so. That's what they're talking about. You don't want to get into that. That's kind of like coercing them, and you don't want to do that. You can direct them into your opinion as how you see things from your expertise. But again, you don't want to get into an area where it seems like you're coercing them into something. And we're going to do some clarification on that off of the committee notes, because they have a revision on this. Previously, the committee notes are tuned in, and this rule here was adopted in 1992 of the former rule of 1090. So they revised it in 2000. Mediators who are attorneys should note Florida Bar Committee of Professional Ethics formal opinion 86-8 at 1239, which states that the lawyer mediator should explain the risk of proceeding without independent counsel and advise the parties to consult counsel during the course of the mediation and before signing any settlement agreement that he might prepare for them. So you could, for the attorneys, again, there's some leeway for attorneys versus non-attorney mediators. There's some leeway. So you can explain to them the settlement agreement that you're drafting up. If you're drafting up the agreement, you can explain to them what you're drafting up, what's going to be in it. If they don't understand like a certain word, like let's say a legal terminology, like let's say, let me find a rare one. One of the rarest legal terminologies is res judicata. Res judicata is a terminology that states that the person cannot file the same claim against you in court. So they can't, if you had a dispute, a construction dispute, and you and them resolve this particular construction dispute, let's say over leveling of the floor, they can't, the res judicata states that you cannot take that same claim and come back later on when you guys sign this agreement and go back in court and refile on that same claim again. That's what res judicata. So the public or pro se would not know what res judicata means. They would not know. So if they ask you what that word means, you can explain it. That's not giving advice, that's explanation. The primary role of the media is to facilitate a process which will provide the parties an opportunity to resolve all parties of dispute by agreement. If any choose to do so, a mediator may assist in the endeavor by providing relevant information or helping the parties obtain such information from other sources. That's like me. I have helped them find other sources. Like if they say, hey, do you know a good attorney? I don't pick any particular attorney. We have here in the States what you call legal aid. I just say, hey, there's a legal aid. You could contact them and they could help you with that information. So I try to keep it as simple as I can for them. A meeting may also raise issues and discuss strengths and weakness of position underlying the dispute. So what that's saying is that you could say, hey, if they say, you say, hey, I understand you feel like, let's say employment. I understand you feel like your employment case is worth $1 million. But to be honest with you, I really think that that's not a strong position, of your case. So that's just explaining them the risk that they're going to take. Because everybody wants to go to court, but they don't understand the risk in going to court. So you could raise those concerns and the weakness and the position on the line of the dispute. So you can do that. Finally, a mediator may help the parties evaluate resolution options and draft settlement proposal. So you can assist them in drafting their proposals. And that's what you're there for, because you're the one who's going to be drafting the stipulation or the agreement anyway. So you want their language. Each party is going to want something to go into. Let's use a landlord and tenant dispute as an example. We have the landlord says, I want this guy out. The guy says, I don't want to leave, I have nowhere to go. So the landlord, now that they both come to a resolution, the landlord will say, I want him out in 30 days. And I want to make sure that the place is clean and his room swept. Then you're gonna put that language into the agreement. The tenant may say, okay, I would like my deposit back and I need my deposit back in 15 days. Can you put that into the contract? That's you helping them put that language together to draft the contract. Because the landlord may say, hey, I'm not going to give him his deposit back till 60 days. And he don't want his deposit back in 60 days. He need his money now so he can move into a new place. So both parties agree that he could get his deposit back in 15 days. So then you'll put that line item into the terms, into the agreement. So again, so you're helping them to draft that contract together, so you can do that. So finally, a mediator may help the parties evaluate resolution options and draft settlement proposal. In providing these services, however, it is imperative that the mediator maintain impartiality and avoid any activity which would have the effects of overriding the parties' rights of self-determination. While mediators may call upon their own qualifications and experience to supply information and options, the parties must be given the opportunity to freely decide upon any agreement. Mediators shall not utilize their options to decide any aspect of the dispute or coerce the parties or their representative to accept any resolution option. While a mediator has no duty to specifically advise a party as to legal ramifications or consequences of a proposed agreement, there is a duty for the mediator to advise the parties of the importance of understanding such matters and giving them the opportunity to seek such advice if they desire. So again, once you drafted the agreement up for them, you could tell them at the end, hey, if you have the time to review this before you sign it, you can seek out legal counsel before you sign the documents, so you know exactly what you're signing. Or you could explain it to them what it is, but always tell them at the end. I always tell them, I say, hey, I draft this up for you, but if you're not certain on this, don't sign this unless you have some type of clarity, and you can seek out legal counsel if need be. So you can explain that. Fees and expenses. Generally, mediator holds the position of trust. Fees charged, and this is rule number 10380, fees and expenses. So a mediator holds a position of trust. Fees charged for mediation services shall be reasonable and consent with the nature of the case. So you don't want to take a particular, say like a employment case. It's always an employment case. So I'm going to go ahead and charge them $2,000. And then, you just got to be, they come to us with trust. Again, we're in the legal field where trust is at the highest with us. They come to us because they don't know, and we're the only one that can assist them in resolving the dispute. So when it comes to your money, just be straight and clear up front. Don't try to have any hidden fees and hit them with stuff after the mediation is over, and then send them an invoice with something that they did not know that was going to be there. So just be aware of what you're doing when it comes to pricing. And Any charges for mediation service based on time shall not exceed actual time spent or allocation. Charges for costs shall be for those actual incurred. All fees and costs shall be appropriately divided between the parties. I always say that's a good rule. It should be divided, but I would say it depends. I've had in mediation where one party have decided to pay more than the other one, and both parties agree to that. Or sometimes I've had where the other party says, and you can find that in some commercial cases. If you're doing commercial dispute where, let's say it's like a grocery food chain store or a big box store or a mall or something like that, anything commercial, and it's a commercial and consumer, sometimes the company would say, hey, you know what? This is a consumer. They've been a consumer for a long time. We appreciate them bringing this matter to us. We did not want to reach to mediation, but we're glad we're here and we're here now. We're going to go ahead and cover the expenses of this mediation process for the other party. So you'll find that in a lot of commercial disputes that they'll cover the expense for the consumer. Written explanation of fees. A mediator shall give the parties or their counsel a written explanation of any fee and cost prior to mediation. The explanation shall include the basis of the amount of any charges for service to be rendered, including minimum fees and travel time. When it comes to fees, I'm going to skip most of this because most of this I'm going to explain to you in one jump. When it comes to fees, all of this should be in your engagement letter. When you send out your engagement letter to the parties for mediation, all your fees should be included in that engagement letter. So you should have in your engagement letter, you should have how much it's going to cost. Let's say I charge $350 per hour. I let them know it's $350 per hour. Minimum 3 hours. Any additional hour after that, I'll charge. I have like $150. I'll break it in half and say it'll be $150 each hour after the 3 hours. And then if it's where I have to travel, let's say it's out of state, I will explain to them there'll be some travel time for hotel, rental car, and things like that. And that's usually split between both parties. So at least everybody is clear and upfront what's going on. So once they sign that engagement letter and send it back to you, then you know that they accept all your fees. So it's a clarity for both you and the participating parties of what the fees is. And then in the engagement letter, you will let them know that fee is split between both parties. So one person ain't feeling like, oh, I'm spending, let's say it's $900 just for me. You got to let them know, no, that fee is split, is shared between both parties. So let's go down to conduct of mediation. So this is Rule 10.420, conduct of mediation. Orientation session. Upon commencement of the mediation session, a mediator shall describe the mediation process and the role of the mediator, and shall inform the mediation participants that mediation is a consensual process. And all of this here, the conduct of the mediation, this is in your opening statement. So when you have your opening statement, I don't know if you guys have a training on opening statements yet, but in your opening statement, most of this stuff is going to be in your opening statement. But we're going to go ahead and we're going to read them off so you know. Mediation, a consensual process. The mediator is an impartial facilitator without authority to impose a resolution or adjudicate any aspect of the dispute. And so again, most of this is in your opening statement, so just keep aware of that. And some of this stuff you can take in and use in your opening statement that I'm reading off to you. Communication made during the process is confidential except when disclosure is required or permitted by law. Remember, earlier I told you that here in Florida, that's required to have in your opening statement. That's mandatory in Florida. It has to be in your mediation opening statement in Florida. It's mandatory. And what that's saying is that we will break confidentiality if we feel that you're going to harm yourself or you're going to do harm to others. So that's what that's about. And that has to be in your opening statement. Adjournment or termination. A mediator shall adjourn the mediation upon agreement of the parties, adjourn or terminate any mediation which, if continued, would result in an unreasonable emotional or monetary cost to the parties. If I see like I'm going over the price that I'm charging them, I usually stop the mediation and say, hey guys, we're at the third hour. It don't seem like you guys is gonna go anywhere. I'm just gonna call this a impasse. But if you guys feel that you guys want to continue to resolve this issue, this is how much I'm gonna charge you to continue, and we could continue to resolve the dispute. So as long as, again, mediation is all about communication, not just with you, but with both parties. Communication is one circle in mediation, is not halfway, it's one circle. It goes around and around. So as long as you explain to the parties what's going on and let them make their own choice based on what the information that you represented to them. So terminate any mediation is in the physical safety of any person endangerment by continuation of mediation. Again, if you feel somebody's threatening, if you're doing an in-person mediation and you feel this other person wants to fight that person, I've seen it. It's usually in family courts disputes. The family mediation disputes is a whole different ballgame. Everything is heightened. If you have this woman who wants to take this man's child away from him, it gets so heated, he may jump across the table. So you could terminate the mediation right there and then. Or if you feel unsafe, if you're in a room with several family members and you feel like an all-out brawl is gonna take on, you shut that mediation and get yourself out of there. Don't put yourself at risk. But you try to de-escalate the situation first. So I would say mediation. I would try to see if there's a de-escalation course out there. I mean, I might talk to the facility here and see maybe teaching a de-escalation course. De-escalation helps in mediation to when people is heightened and they're so passionate about something, and you have to de-escalate. You have to bring that temperature down in the room. In order to keep everybody in the room under control. Remember, you're the mediator. You're there to keep everything contained from getting out of hand. So if you feel like one party is not thing, you might have to separate them in the room. Not all mediations can be done in joint sessions. You may have to separate them. Sometimes some mediation have to be in a joint room because the information is so overwhelming that you need both parties to interact a little bit, but you have to know how to take charge of that mediation. If you're gonna put them in a joint session, you have to be able to take the reign of that mediation and hone them in and say, hey, this person is talking, please don't interrupt this person while they're talking, because me as the mediator, I need to get clarification to help you guys resolve this. And if you talking and they talking, I can't figure out what's going on. So that's gonna help. Closure. The mediator shall cause the terms of any agreement reached to be memorialized appropriately and discussed with the parties and counsel the process of the formation and any implementation of the agreement. I think we only got a couple more to go. Schedule mediation. You guys should know about that. This is rule number 10.430. The mediator shall schedule the mediation in a manner that provides adequate time for the parties to fully exercise their rights of self-determination. A mediator shall perform mediation service in a timely fashion, avoid delays whenever possible. Again, that's why we're here. Is we want it to be ethical, we want to be responsible, we want to maintain the integrity of the mediation process. Rule 10.500, mediators' responsibility to courts. That one, well, I'll give you that because I don't know, that might help you guys. A mediator is accountable to the referring court with ultimate authority over the case. Any interaction discharging this responsibility, however, shall be conducted in a manner consent with these ethical rules. Meaning if you're in the courthouse and you are doing mediation for that courthouse, the mediation case is yours own, but again, you're supervised under that courthouse and you want to keep the integrity and be responsible of whatever that particular court wants their mediation to be done. Some courts mediation, they want it to be done certain cases in 45 minutes. If there's particular cases that can't be done in 45 minutes, you have to let, that court administrator know that, these certain cases can't be done in 45 minutes. And they're usually fine with that. Information of the court. A mediator shall be candid, accurate, and fully responsible to the court concerning the mediator's qualifications, availability, and other administrative matters. Rule 10.520, compliance with authority. A mediator shall comply with all statutes, court rules, local court rules, and administrative orders relevant to the practice of mediation. Rule 530, improper influence. A mediator shall refrain from any activity that has the appearance of improperly influencing a court to secure an appointment to a case. That means that you don't want to call up the court administrator and say, hey, my friend has this case. Can you see what you can do? That's going to get you into big trouble. So definitely avoid that one. Rule 10.600, mediator's responsibility to mediation profession. A mediator shall preserve the quality of the profession. A mediator is responsible for maintaining the professional competency and forthright business practice, fostering good relationship, assisting new mediators, and generally supporting the advance of mediation. That right there is the bread and butter of what we do. We are professionals. And again, I'm going to read that one again so you guys get it. Mediator's responsibility to the mediation profession. A mediator shall preserve the quality of the profession. A mediator is responsible for maintaining professional competency and forthright business practice, fostering good relations, assisting new mediators, and generally supporting the advancement of mediation. So that means with new mediators, if you have to let them absorb you, let them absorb you. Don't be like, this person's taking bread out my pocket. I don't want them to absorb me. Trust me, it's plenty of disputes to go around for us, everybody to eat off this plate. So don't feel like a new mediator is going to stop you from eating. There's plenty of food to go around. And who knows, that new mediator that you're saying is new, they may have connections to where they might bring you in on a case. So don't cut yourself out of feeding your own self either. But we want to grow this practice. That's why this ethical rules is in place. So we want this head to remain professional at all times. We want to keep this profession going. We want the public to see this as another resource for litigation. Because litigation in the court, that's costly, it's expensive, it's lengthy. So we want them to see mediation as the first option, not the second option. I always want to say the first option because it saves them so much money. And most of the times, I've seen where somebody just says, I apologize for what I have done to you. And I've seen mediation close out like that in under 10 minutes. All they wanted was an apology. So again, we got to keep the question real good. Here is, if you have a mediation practice, and I'll be teaching that class tomorrow. This part right here, Rule 10.610, the marketing practice. This is where you will get yourself in trouble if you do things wrong. Yeah. I've seen it happen. I'll sum all this language up. I'll sum it up in one thing. Be truthful. One, do not say that you can solve their dispute. That's not true. You're assisting them. Do not tell them that you can guarantee to resolve their dispute. That's true. It's up to them. It's up to both parties. You don't go in there like a judge. This is not arbitration. You don't hand down an award or a judgment on their case. This is both parties sitting in and having a conversation with each other and trying to resolve the dispute. But we can run through the marketing practice so you understand. False or misleading marketing practices. A mediator shall not engage in any marketing practice, including advertisement, which contains false or misleading information. A mediator shall ensure that any marketing or other mediated qualifications, service to be rendered, or the mediation process is accurate and honest. Supreme Court certification. Any marketing practice in which a mediator indicates that such mediator is a Florida Supreme Court certified is misleading unless it's identified at least one area of certification in which the mediator is certified. So in Florida, I can't say I'm Supreme Court certified. I have to say I'm Florida Supreme Court certified county, circuit, or appellate, or family dependency. It has to have those endings. You can't say I'm Supreme Court certified. That's going to get you in trouble. That's misleading marketing. You have to say I'm Florida Supreme Court certified county if you're county certified. If you're circuit certified, then you have to say I'm Florida Supreme Court certified county, circuit certified, etc. Other certifications. Any marketing publication that generally refers to a mediator being certified is misleading unless the advertising media has successfully completed an established process for certifying mediators that involves actual instructions rather than the mere payment of a fee. Use of the term certified in advertisement is also misleading unless the mediator identifies the entity in issuing the reference certification and the area or field of certification earned in application. Like again, let's say what they're saying there, if you're gonna market yourself and you're gonna say like I'm certified relationship mediator, then you have to say, let's say it was my school or settlement house. You say, I am certified by Settlement House as a relationship mediator. So that's what it's saying in that paragraph. You just can't say I'm a certified relationship mediator. Okay, who certified you? So what they're saying, if you're gonna advertise it, you have to say I'm Settlement House certified relationship mediator. So that's what it's saying in that subject right there. Prior to objective experience, any marketing practice is misleading if the mediator states or implies that prior adjudicative experience, including but not limited to service as a judge, magistrate, or administrative hearing officer, makes one a better or more qualified mediator. So in that part right there, they're saying that if I'm a retired judge and there's a paralegal who's a mediator, the judge can't say, well, I'm a better mediator because I'm a judge versus that paralegal who's a paralegal who became a mediator. What they're saying, you can't say that because I've seen paralegals who become mediators is actually better than judges. And I've seen a lot of non-attorneys mediators that's better than attorney who's a mediator. So that statement right there is saying that you can't say that. You can't say that you're better because you're a judge. That's not true facts, and it has not been proven. So prohibit claims of promises. A mediator shall not make a claim or achieve specific outcomes or promises implying favoritism for the purpose of obtaining business. So again, that goes back to what I was saying, that you cannot say, hey, I can resolve your dispute for you. You can't do that. That's going to get you in trouble. Additional prohibiting on marketing practice. A mediator shall not engage in any marketing practice that diminishes the importance of a party's rights to self-determination or impartiality of the mediator, or that demeans the dignity of the mediation process or the judicial system. here goes integrity. So rule 10.620, integrity and impartiality. A mediator shall not accept any engagements, provided any service, or perform any act that would compromise the mediator's integrity or impartiality. Again, that means don't accept gifts from some party, especially if you get out of a commercial business and they send you a gift. Don't send it, because if that person prevailed and the other person finds out, they can say, oh, you helped them out, you show favoritism to them. That's going to get you in trouble. Professional competence. A mediator shall acquire and maintain a professional competence in mediation. A mediator shall regularly participate in educational activity, promoting professional growth. So that's just saying, just keep up with your continued education, and grow yourself. Don't just get your certification and then be like, okay, I got my certification, I'm the bomb now. No, it's saying continue to grow, continue to learn, because I remember mediation is an evolution right now. It's growing. So always keep up with the latest things that's going on out there. Rule 10.640, skill and experience. A mediator shall decline any appointment, withdraw, or request appropriate assistance with the facts and circumstances of the case are beyond the mediator's skills or experience. What rule 10.640 is telling you, don't take cases that you don't have the qualifications for. So if you don't know nothing about construction, do not take a construction case. I know we all feel like I could mediate everything. If they get in front of me, I could mediate. No, there's some things that you don't want to mediate. And let me give you an instance. I had a mediator that called me up, and he took a case, and it was intellectual property, infringement rights and things like that. He has no training on that. It's a lot of laws that goes on there, a lot of things that goes on when it comes to intellectual property and infringements and stuff like that. He knew nothing about it. He took the case on, and the whole time, immediately up and call him to assist them all the time. And I try to explain to him that you should have never took this case on. So, long story short, he had to bring me in as a third party to assist him in resolving that dispute. So they had two mediators instead of one, because he took on something he was not qualified for. So stick to what you know, and you'll be. It seems like, okay, there we go. Are we good on time still? I'm gonna skip some of them. I'm gonna go through some of them. Let me see. This is relationship and to others. Huh?
Yes, the time is up. We just round up final comments and then.
Okay. So I think we're pretty much done. That was it. Yeah, that was it right there. So pretty much in mediation, I just want to say with the ethics, like I said in the beginning, remain professional at all times, and you should be good. Even when others are being unprofessional, just remain professional, and everything is gonna be good. And when it comes to advertising, if any business owners out there, when it comes to advertising, just be truthful in the advertisement that you put out there. And again, thank you guys for having me. It's been a pleasure. It's always a pleasure working with the Settlement House and the training program. You guys are learning from the best. So keep it up. Tell your friends about the Settlement House and the great things that they're doing. And with that, good morning, and you guys have a wonderful rest of your day.
Thank you, sir.
I'm sharing.
Very much, sir, for that wonderful session. We really appreciate you for that. Well, I believe that the participants have different perspectives when it comes to ethics in mediation. So we try to see that they are exposed to different understanding of what is expected of them, not only as practitioners here in Nigeria, but as practitioners also in people who are intending to become practitioners, even internationally. So thank you very much for that. Do we have any question? If we do not have, we will say thank you very much, Mr. Lloyd.
I have a question.
Okay, go ahead.
Okay, so my question is, in the case where you feel as a mediator that you are not so competent, maybe in the case that I'm in resolving that dispute, can you seek the aid of another mediator who is competent in that regard, and you mediate together over the dispute? The reason why I'm asking this is because I know that the rules of professional conduct allows a lawyer who is not as competent in a particular field to seek the help of another lawyer. So that's why I'm asking that, does the same thing apply in mediation practice? Can you seek the help of another mediator who you know is more competent or well experienced in that field to help out, and you mediate together as co-mediators? Thank you.
So the answer to the question is yes and no. I'm gonna go with the no first. The no is why I said that it's best to take on cases that you have the knowledge about. That way you avoid that problem. The other to the yes now, if you have a mediation that you feel that that the parties want you, but you know that you need help, then you could say, hey, I'm going to have a co-counsel with me. I'm going to have another mediator with me to assist me in resolving that dispute. And that would go into your engagement letter, and you will let them know, this particular case, I'm going to need another mediator in it on me. And once you send an engagement letter out and they agree to it, then you should be fine. But they have to agree to it. Remember, this is their mediation, and they have to agree to who's going to be mediating their case. And if there's going to be an extra fee for that mediator to be there, then that has to be known to the parties also, that they're going to be charged an extra fee to have two mediators versus one. But if that mediator is not going to charge you any extra fee, then you let the parties know it's going to be the same cost for one mediator.
All right. Thank you very much, sir.
No problem. I say, Igodu, what's the question?
Yes, sir. Sir, in a mediator, when one party approach you to mediate in a dispute, how do you bring the other party into the mediation? When only a party approach you to mediate in a dispute, how do you bring the other party into the mediation process?
Okay, say it again, because you was breaking up.
Okay. In a mediation, in a dispute, when a party approach you to mediate in a dispute, how do you bring the other party into the mediation process? If it's only one party approaching you,
You seek for permission.
Yes. So yeah, so if one party approaches you and then the other party don't, then you ask the other party, because remember, it takes two to tango. So it needs it needs both parties in order to resolve the dispute. So you would always seek permission from both parties to resolve the dispute. And what you would do if one party reaches out to you and say, hey, I have this dispute, I would like it to get resolved. then what you would do is you would send an engagement letter. This is a different type of engagement letter. Is a letter to resolution letter. And that letter to resolution is sending out to the other party, hey, this party, let's say Mr. Johnson, so-and-so, he would like to resolve this dispute that you and him have. He asked me to be the mediator for you guys, and he would like to resolve this dispute through mediation. Would you accept this letter as to resolving your dispute through me as your mediator? And then if that person accepted it, then you will start and say, okay, I will send you another letter. It's going to be an engagement letter, tell you the time, place, and date of the mediation. And that's after they accept it. Does that answer your question?
Yes, sir. Thank you, sir.
No problem. Any more questions?
Thank you very much, sir. In the absence of further questions, I want to appreciate you greatly for the time. As 5 a.m., you've been out to speak to the participants, and I know that they will be grateful to connect with you eventually. Thank you very much. I want to appreciate you on behalf of the management of Settlement House ADI Training Institute for that wonderful presentation on the very important and critical aspects of the mediation process. So thank you very much, sir. And
thank you so much. Thank you. And you guys have a wonderful day. If they turn their cameras on so I can take a picture so I could put it on their social media.
So having said, oh yes. Please, let's put on our camera. Sorry, I have to even have okay. So
Sir,
okay,
you
so
off
let's
my
put on our cameras, please.
off by you, sir.
Let's put on our cameras, please. Quickly. Let's have a snapshot. I cannot see us putting on our camera.
Everybody just have the camera.
Cameras on.
You off my camera, sir. Off my camera, sir. God bless is speaking. Okay.
I think Mr. Nunchang got knocked off, so I'm gonna stay on till he gets back on since it made me the host. Okay, there you go.
Yeah, hold on. Yes.
Okay.
Okay. Mr. George, were you able to take that?
Yes, sir.
Okay. Kindly
Yes.
share with.
Yes, I would definitely share that. And I'm
Alright.
off to my next appointment.
Thank you. Have a nice day.
Same to you guys. Thank you guys for everyone, and enjoy the rest of this training material, and I'll see probably most of you guys tomorrow.
Yeah, see you tomorrow morning. Thank you.
Okay, you guys take care. Bye.
Bye-bye.
Bye. Thank you, sir.
Can we put off our cameras now?
Just a minute. Okay, oh, this is great. This is great. The thing is coming back. Okay. Okay. Okay, we are good. We are good. Okay, so we are going to be looking at okay, so can you all hear me?
Yes, sir.
All right, thank you. So we are going to be looking at negotiation skills briefly. Yeah, so I want someone to tell us what he or she understands by negotiation. Who can tell us what he or she understands by negotiation?
I trust we are all having a nice section. Can we all hear me? Can I go ahead?
Yes, please go ahead.
So I think in my own understanding, negotiation is communication between two or more people with the sole aim of reaching an amicable settlement or a mutual agreement. So it's a form of communication between, it can be two or more parties, but the sole aim is to reach a mutually agreed settlement or agreement. Thank you, sir.
All right, thank you. I can see Adiza.
Yeah. Good morning, House. My own understanding of negotiation is a discussion between two parties with the aim of reaching an agreement or a settlement.
Okay, thank you very much. Malam Bako.
Yes, sir. Yeah. Negotiation is the act of meddling between two conflicting parties to broker peace.
Can you say that again?
Yeah, it's the act of meddling between two conflicting parties to broker peace. The negotiator is the third party that stands with.
Okay. Thank you very much. Okay, so who can define what mediation is?
Pardon, sir, can you come again?
It's an
Who
assisted
can define what
negotiation.
negotiation is?
Okay, we're just done with that. I thought you were talking about mediation.
Hello? Okay, Blessing.
Repeat the question.
What is mediation?
Okay. Let me attempt, sir. My own understanding of mediation is facilitating an open communication between two parties with the sole purpose to reach a collaborative mutual agreement or settlement.
Okay. Okay. Thank you very much. Negotiation is actually, mediation is actually an assisted negotiation. You get? Negotiation usually is between the parties in disputes, but where there is a deadlock and the parties cannot continue, what they do is if the parties cannot continue, they get the assistance of a third party neutral, who is called the mediator. The third party neutral is the mediator. Can you hear me? Can you hear me?
Yes, sir.
Hear you now.
Please, can you hear me?
Yes, now.
Yes.
Yes.
Yes, we can hear you.
Thank you very much. So we were talking about negotiation, and we said that can you see the slide? Can you see the slide?
Yes, sir.
Okay. So negotiation is something that we do every day. And the essence of taking this class is because the mediation itself is negotiation. It's just like it's assisted by a third party. And we want to know the tools you use for effective negotiation. And at the end of this class, we're expecting participants to be able to understand the various skills that you need in order to conduct an effective negotiation. And then you should be able to demonstrate these practical skills in negotiation. And then we expect that participants will be able to understand the various stages and processes involved in negotiation. Now, having said this, okay, I don't know. Can you see my screen?
Yes.
Now, negotiation is something that we do every day, whether you are a worker, whether you're an employee, whether you are a businessman, whether you are a family man, you have children. Why do we negotiate? We negotiate because we want to gain an outcome that is acceptable by all of us, by the parties involved in the negotiation. Now, there are stages in mediation, in negotiation. You have to look at the preparation stage, the proposal stage, the debate stage, the bargaining stage, and the closing stage. And you see, it is important to know that if you do not plan for something, he who does not plan has planned to fail. If you don't plan for something, definitely that thing can come and take you by surprise. So preparation is key in everything you are going to be doing. Preparation is key. Preparation is key. So that's why it is important for us to understand what do you do if you are preparing for please, Luis, if you are not speaking, please can you put your mic on side? Okay, I know what to do. So we're going to do it. Okay, good. All right. Okay, so here we go. So the processes and stages of negotiation. All right. At the preparation stage, what do we do? If you can hear me, you can give me a thumbs up. I have to mute everyone. You are going for a negotiation. Your company is involved in a dispute with another company, and then you discover that there is need for you to discuss and get an outcome that is favorable to two of you. time is of essence and you cannot afford to go to the court considering the issues. So what you do during your preparation stage, you want to first identify or clarify your objective. What do you intend to achieve in this negotiation? What do you intend to achieve? What are your goals? Why are you negotiating? You are negotiating to buy more time so that your company will be able to pay. You know, that will guide what you do. If you are negotiating so that, if you are negotiating so that you'll be able to get the parties to, the other party to accept maybe an amount that is different, you know, is lower than what they are claiming, that may be your objective. It is your objective that will determine what you need to do and the kind of preparation you need to do. So after you set down your objective, you know what you are going for. If you, there is a saying that when the purpose of a thing is not known, then abuse is inevitable. Now you don't want to abuse that opportunity, so you want to identify also in your objective, what is the limit? You know, we've talked about initially, we talked about your partner, your partner. What is the best alternative to the negotiated settlement? What is the worst alternative to the negotiated settlement? You know, so what do you do? What are your no-go areas? If you are representing a company, you want to know, okay, we want you to negotiate between 1 million to 1.5 million. You know that that is your limit. You cannot go beyond, go and agree to an amount that is not within that range. So you identify your no-go area so that you know in your negotiation, you know. And when you go, you don't just go and say, okay, I don't want us to waste time. I will just give you 1.5 million. When you start like that, you know that at the end of it, you may not be able to conclude. So what do you do during this stage? Then after you set your goal, you identify your limits, you now make research. You research the case, get to understand the case properly, get to know the history, the origin, you know, the parties that are involved. What is their interest? What do they like? What don't they like? You know, do you have common interest? Yeah, you have to study, make research, find out information that will support your objectives. Then you need to assess the other party, just like lawyers. What could be their defense? You know, for example, are their case stronger than ours? Let's say you have a situation where there is, let's say, your client his employment was terminated and he wants to take an action. And in that action, you know that he has 1 month within which to take that action, or that he needed to give a notice or pre-action notice, which is statutory, and he has not given. And the parties have agreed that they will meet with you to negotiate. You see, those things are going to be very critical because you know you have not actually activated the jurisdiction, so to say. You have not given that notice. So, and if you have not given the notice, it means that any other thing you are doing, you are just wasting your time. So these are some of the things you need to find out. So you study the case, study the opposition, get to know their weaknesses, get to know their strengths, then the background. A common ground to enter. Do they have weaknesses that you can use to enter? And all of those things. Those are some of the things that you need to be looking at in the course for negotiation. Try to get a neutral ground. Don't go and sit in the office of the person you are negotiating with. Get a neutral ground, and then where nobody is going to have control of that particular place, so that there will be a neutral ground. Parties can discuss freely. There is this idea of home advantage. Mona Igidani, we did for house. Now us, you know, if it come beat us for house, you know, that kind of thing. So you need to take note of that. Then the next stage you need to go into is the proposal stage. The proposal stage is similar to your opening statement. At this point in time, you see someone is saying his own side of the story and he's saying it. When you are saying, you know, you are saying what you are proposing, you are telling this is what the story, this is what happened, and this is what I want. When you are doing that kind of thing, you are making your proposals. You are making the other party know what you want. Then so you are making the other party to know what you want. And in that case, if you are doing that, it's expected that when you are saying your own side of the story, say it in a very, very confidential manner. Don't say it as if you don't know what you are saying. You are not even conversant with the facts of the case and all of those things. You have to consider that very, very seriously. Now, one thing you need to do is that when you are saying your own side of the story, don't go and say, okay, if you don't pay me 10 million naira, just forget about it. You are not going to negotiate. You know, you need to leave room for a kind of adjustment and movement. Because when you go and in your proposal, in your opening statement in the negotiation, you are saying, I'm going to, this is what you must pay me. If not, we are not continuing. You see, that is very, very disastrous. That is very, very bad. You know, you have already spoiled, you know, the thing. So you need to leave room for negotiation. And then perhaps, you know, when you want to make a proposal, make it hypothetically. You know in your mind that what you are looking at is 2 million. You can decide to say, okay, we are expecting you to give, you pay us 10 million naira for this particular thing, you know, so that you can now negotiate. Don't put an amount that is fixed. That amount we are using is for example. It could be any other thing. It could be the subject matter of the negotiation. So you need to take note of that. It's very, very important. So, you look at, that's at the proposal stage. Make proposals that are hypothetical. So we are expecting that you will be able to pay us so because of what we have suffered. You have explained the justification. Then as you are talking, you should also allow the other person to speak. Don't be the one to always talk and you are interrupting the other person. Let them have the sense that you are also listening to them. Then you need to take note. It's very, very important. Take note. Take note of all that you people have discussed. If this person is saying that, okay, we were willing to offer so amount of money, or that they are also claiming something, because that's what is called counterclaim. A person can be counterclaiming against you. So you need to take note of that. Very, very crucial. Now there is a bargaining stage. You have now made your proposal. Now you are doing a kind of bargaining so that you come to a consensus. What do you do? This bargaining stage, remember we told you that there are 5 stages. You have the debate and bargaining. The debate and bargaining goes side by side, you know, because at this bargaining stage, you are discussing. The person says 10 million, you say, oh, because of this, and that. Let's say, for example, a woman, a lady was impregnated, and then because she was impregnated, she has to stop her schooling. Then you come at the negotiation table, you say, you have to pay us damages for this, and that. And the damages is 10 million naira. Then after you finish speaking, the other side will come up to say, okay, you see, the issue is that this boy and this girl actually agreed. They said they want to marry, and they know that as a parent, you are not going to allow them to marry themselves. So they plan so that the lady can become pregnant. You have made your proposal and you have reasons backing them. But when you hear the other side, you get to know that, oh, you know, it will be so disgracing and embarrassing to hear that these people are actually connive, you know, to do this particular thing. So you see, it will affect your proposal. So they will be saying that, okay, because this thing is something that is intentional and they did it intentionally, it's not as if we are at fault or our child is at fault. It's something they agree. So because of that, we are acknowledging that this thing has happened, but we are going to give you 500,000 naira. And what we are looking at, we are going to take care of the baby, take care of any other expenses. That is proposal, that is concession, that is negotiation, that is bargaining. You are bargaining and they'll say, no, consider our daughter, she will spend 2-3 years. Imagine 2-3 years of her life out because of this pregnancy and because she needs to raise the child and all of those things. So these are the things you'll be looking at. So you exchange your positions, you discuss, and then when you are going to be making offer, let's say they say 10 million, you are on the other side, you are going to make concession. You say, okay, start from the smallest amount. Don't go and say all the amount that you are authorized to give, because if you start at that high level, definitely you may not get to. So when somebody have high expectation, you dash the expectation by giving a smaller amount, offering a smaller amount. Now, for any reason, if for any reason you are going to agree to a proposal or you want to concede to anything, don't do it in such a way that you say, they've got me here. So when you do that kind of thing, the other side will take note. So don't do it in such a way that you are putting a losing face. Say, so these people connive, and then the girl became pregnant because they want us to say, these children, they've killed me, or what am I going to do? And you are doing that in the face of the other people. They will say, we've got them here. They will pull and pull and pull that trigger and then begin to offer some tactics, threats here and there, so that they will be able to get a better side of the negotiation. So when you are compromising, don't do it in such a way that you are losing. Do it in such a way that the other person will know this thing that I'm conceding, I'm conceding is something that cost me. I'm losing for conceding to this thing. So that the person at the end of it, there will be a balance. Everybody will know that, yes, I gave something, I received something. Not that one party wins all. That's the essence. So when you are going to be making proposals, you can make assume proposal. Don't make, you want to test the ground to see. You say, okay, assuming where we do not have money to pay, but we are hoping that things will get better. But any expenses that has to do with child delivery, feeding, birth, schooling, we are going to take care of it. Would that be okay? You are not saying you are going to do it, but you are testing the ground. You are assuming. When you see a favorable answer, you can now say, okay, we want to do it. We want to take care of this baby. We want to do all of these things. You see, you have tested the ground. So when you are making proposal and bargaining, make assume proposal, because it is bargaining, so that the person will not hold you by your word. If you say something and later on turn around and say, I didn't say so, no, we are withdrawing it, then the person will see you as an untrustworthy partner, someone you cannot trust in the process of the negotiation. But when you make assume proposals, assume proposal will give you the opportunity to be able to withdraw your proposal at any point in time and test the ground, so that you know whether your proposal will be accepted. And when you see a favorable answer or response, you can now say, okay, we are going to do it. These are some of the things you do. And very important, don't actually concede. Don't concede. Don't concede. Don't concede until you receive something in return. Even if it is okay, you must pay us 10,000 naira and you agree to paying the 10,000 naira, you must insist that they are not going to get that payment the way they are asking. Let's say we want the money to be paid at once. You may have the money and say, okay, no, we are going to pay twice. Even if you are going to give us like 2 hours in between, we'll pay one in the morning, we'll pay the remaining balance in the evening. You are conceding because you are giving concession and you are accepting, and then you are receiving something box in a corner that you don't have any option. So when you are giving, you are taking. It's give and take. Ensure that you put it in that position so that it will not be as if we came, because our case is good, you must do this, you must do that, you must do that, you must do that, and then you are just conceding to all of them, and you are time from morning till evening. At least you have received something. If you say we'll pay first in the morning and then tomorrow we are going to balance up, you have received something and the other party did not. Then the final thing you need to do at this negotiation is first you look at the in the process of negotiation, you are listening to the other party. Take note of their concerns. Interest is very childbearing. We are going to be giving 10,000 naira, for buying pampers. Then we are going to be giving maybe 100,000 naira for feeding and some other things. Take note of all of those things. Record all the agreements you are making. You say, okay, we are going to be feeding the child, and then we are going to be taking the mother to school. We are going to look for an avenue where she can be studying, whether online or she can go to physical school. We'll employ people that are going to be taking care of the baby, that will go along with her to school and bring her back, so that they can take care of the baby while she is in school. All these things, be documenting them and writing them down, so that you will not after everything miss out on important things. When you miss out on something and the other party did not understand or did not record it, you have to go and start negotiating over that thing again. So it's very, very important. Now, after you have recorded all of those things, what you need to do at this closing stage is to confirm. You want to confirm that you want to confirm if what you have recorded are correct. So, okay, in respect to this particular matter, this is what we agreed. You say, yes, this is what you agreed. Good, you tick that one. Okay, you say in respect of raising the baby, we are going to take care of the mother and the baby for 3 years. Yes, this is what we agreed. Okay, feeding, we are going to be paying so amount of money. Yes. How will you be paying at the end of the month? Oh, all those T's and dots and I's and all of those things are the things you are going to be doing. Confirm. Then where there is possibility of ambiguity, you need to clarify. Clarify every ambiguity. Don't go and leave a word that has dual meaning. Somebody say, I am gay. And then you start looking at it and say, hey, this person, so he's a gay. If you check the dictionary, gay has 2 meanings. One, the first meaning is one of the meaning is this issue of a man and a man getting involved with one another. Then the second meaning is I'm happy. That's happiness. I'm gay, I'm happy. That's what it means. So you want to avoid those kind of ambiguity. So when you have a word that has dual meaning, you want to clarify and identify what the particular meaning that you are referring to, so that there will be no ambiguity afterward. So thank you very much for listening to me. I don't know if you have any question. I have Your Excellency, our next speaker is here with us. His Royal Highness is here to teach us on a very important aspect. So do we have any question? If you have questions, put your virtual hand or let me allow everybody to speak. Okay, do we have any question? Do you have question? Emanuela, do you have question? Onela, do you have question? Stephen, do we have question?
No question at the moment, sir.
Okay, it means it's either you over-understood me or you did not understand me at all. Which one is it?
We understood, sir, but not over-understood. We understood.
Okay, you understood. Where there
Yes,
is
but
no
we didn't
question after a
over-understand
class,
it, sir.
I used to be afraid though. When there is no question after the class, it's either the student did not understand all that you are saying, or that they understood it so well.
We were taking the note screen. The screen was clear and the notes just few. So we're taking all. I took almost all the notes.
Oh, that's wonderful. Thank you very much. All right. In the absence of any question, our next speaker is here. Is a very highly esteemed dispute resolution specialist. Mr. Abubakar is someone that you want to relate with. You know, very, very interesting. He specializes in Islamic mediation, and we feel that in this world where we have religion, Christian, Muslim, and the rest, and some of us may want to have an idea. You need to have an idea because sometimes you may have people who are from different faiths. And if you have an idea about what the person's religion says about what he does, you know, it will really go a long way to assist you. And that is why we call him to speak to us on a very important aspect that has to do with Islamic mediation, so that everybody here will be able to have an idea and have an understanding of what it is, what it involves. They usually call it sulh. We talked about both religious and religious and legal framework for ADI, that our religion supports it. Our religion supports it, right? Our religion supports it. So, Mr. Abubakar, let me confirm if you are ready. Okay, Zioni, who is using this device? Yeah, you are muted. Abubakar, you are muted.
Now, do you hear me?
Yes, can hear you.
Yes, I'm on two devices.
Okay, go ahead. I can see.
Okay.
Yes, sir.
Hello, good afternoon.
Good afternoon.
Okay.
Afternoon, sir.
Yes. By introduction, I'm Barrister Abubakar Ali Abdurrahman.
Yeah, I'm going to introduce you, sir.
Okay.
Yes, I will introduce you.
Thank
Okay,
you.
so I just wanted to confirm if you can hear me so that we can.
I can hear you.
Okay, that's good. So, Mr. Abubakar, okay, so Mr. Abubakar is you have seen his profile.
Is it here? We have not seen it.
It has been sent to your WhatsApp platform. Okay. Mr.
Okay.
Abubakar is a lawyer and is a PhD candidate. He is a seasoned legal practitioner for over 22 years of extensive arbitration, litigation, taxation, and contract management and corporate practice experience. He is currently the principal partner of a position he has held since the year 2020. He has proven track record in effective dispute resolution, property management, and legal advisory. Throughout his career, he has held significant positions, including the Chief Officer of Recruitment at Dangote Cement PLC. He was the head of the legal unit of Dangote Cement Transport and the senior counsel at Murtala Musa and Co. His role have equipped him with comprehensive expertise in litigation, among several other things. He is a fellow he is an associate member of the Chartered Institute of Personnel Management of Nigeria and that of Chartered Institute of Taxation of Nigeria, as well as a member of his commitment to the continuous development of professional skills and knowledge is demonstrated through his active participation in events focusing on leadership, human resource, and personnel management. He is a facilitator with the Nigerian Institute of Chartered Arbitrators. Is a faculty member of that prestigious institute. Please join me to welcome His Royal Highness, Mr. Abubakar Afan. Yes, sir. Over to you, sir.
Okay. Okay. So our topic for the discussion of today is mediation under Islamic law, or in other words, mediation under the Sharia. Mediation under the Sharia had been in existence for a long period of time. We can even say since before the advent of the Sharia.
How much is this? 1.3. We don't sell it per one.
So Mr. Abubakar, you can put on your Mr. Abubakar, you can put on your mic.
Hello?
Go ahead.
Okay. I'm taking the historical background of mediation under Islam or under Sharia. That's why I said mediation has been in existence since before the advent of Islam. The Prophet Muhammad sallallahu alaihi wasallam, peace be upon him, was the one where there was a conflict with regard to what is called Hajar al-Aswad. That Hajar al-Aswad, some of the tribes in the Arab area, they insist they are in better position to place the stone in its original place. They appointed him as an mediator or arbitrator or arbiter. On that note, the Prophet himself, being somebody who is knowledgeable to mediate between disputants, he used his own garment and placed it on the ground. He took the stone and put it on the garment. He asked the leader of each tribe to take that garment where the stone was put. When they reached where the stone should be placed, the Prophet himself carried that stone and placed it in its original place. This shows that if not this was mediated by the Prophet, a conflict, a war might emanate as a better position, or who was in better position to carry that stone and place it in its original place. So this is at least a historical aspect that empowers it and every person to mediate or arbitrate between the two disputants. There are so many verses from the Quran that mention that people can mediate between the two disputant parties. That is to say, we have what we call sulhu. This is number one. And we call what is called tahakim. And we call another one fatwa. Then the last one is muhtasib. So these are the four aspects that we will consider how mediation works under the Sharia. Under the Sharia, mediation arbitration, reconciliation, negotiation can fall under these 4 aspects. Because when we say sulhu under the Sharia, the 2 parties themselves can sit together and resolve their own misunderstanding without involving any third party. At the same time, sulhu can be a mediation in which a neutral third party will help or will assist the parties to negotiate between themselves. The third one, which is tahkim, is a situation where you give the third person or the arbitrator to determine the issues between the parties and come up with his own opinion. That opinion is not binding in nature. I hope you are getting my point. Then the last one, which is muhtasib. That is somebody that will see people having a conflict, then he will come by himself and try to resolve that issue amicably. At times he can even, in a case of debt, he say, okay, I will pay the debt. Just because he wants peace to exist between the parties. So now we can call him a peacemaker because nobody appoint him, but you ask the parties' consent. Please allow me to resolve this issue. If they agree, he will resolve it. And in most times, they may not to argue with him. Being an elderly person or somebody who is knowledgeable on the issue. So most of them, if he asks them, okay, please, can you allow me to resolve this issue? They will surrender. So the other one, which is not very relevant, is fatwa. You can go there and ask somebody, please, I have so problem, and I want to resolve. How can I resolve it? That person will give you his own opinion. And if you are satisfied with his opinion, you go and resolve your issue by yourself. We can take this like a private judge. A private judge, you can come and meet a private judge, and you tell him your problem. You narrate your issue. After narrating the issues, then he will give you his own opinion. So you see, this is fatwa. And it is allowed under the Sharia. Am I communicating, please? Hello? I want you to speak. Do you
yes,
understand my point?
Yes, sir. Go ahead.
Hello? Yes, are you with me?
Yes, sir. Go ahead.
Okay. So these are the 4 categories of mediation under the Sharia, and they can be used interchangeably. When you say to Hakim, if the person is not given a power to determine the issue, it will become a mediator. If he is given power to determine the issue, he will become an arbitrator. Therefore, Sulhu or Islamic Sharia mediation, it contains all this. You can see it. Yes. Then secondly, the mediation is like a hybrid in nature. It can be conciliation.
Okay, so let me know when you want me to change the slide, Mr. Abubakar.
Yes, sir.
Let me know when you want me to change the slide.
You can change it because we have already discussed this first.
Okay. Have you gotten to this place?
Yes. Yes.
Stop here.
Yes. This is the authority. Under the Quran, chapter 5, verse 35. This chapter, the verse authorize the member of the family of the couples or spouses to be appointed as an arbiters. And they were empowered to reconcile between the two spouses. And if the spouses are ready to reconcile, God will help them to reconcile via those arbiters. But the most important issue at this is for us to understand there are two types of mediation under the Sharia. Because our concern in this lecture is to know mediation in details. There are two types of mediation under the Sharia. We have traditional Islamic mediation. Secondly, we have modern Islamic mediation. Therefore, in traditional Islamic mediation, there are some very important elements which they are the same of the ADR we know, alternative dispute resolution. So these elements are very important. In fact, they are the bedrock of the mediation. Our discourse on this issue is on the mediator, not the parties, because the presumption is the mediator is knowledgeable enough because he made his own research and he has the facts at his fingertip. Therefore, number one, he must be neutral. He must be impartial. This is very important. Neutrality under Islamic mediation is very fundamental. Even if it is one party or the both parties, or even if another third party appoints that mediator must be neutral. This is number one. This is one of the essential elements of mediation. Secondly, the mediator's decision is not binding on the parties. So look at this. It's almost same as in our own conventional mediation. Why? Because it becomes binding on the parties if the parties sign. That means they accept with the decision of the mediator. I hope you are getting my point. Any mediation, even whether it is written or not written, parties must accept that decision. Failure to accept, or when somebody refuses to agree with that decision is not binding because it is not judgment. So this is the second fundamental aspect of traditional mediation. Secondly, or thirdly, Islamic mediation between the parties is hybrid in nature. The nature of the case will determine whether the mediator will be mediator/arbitrator or will be arbitrator/mediation. If we remember, in our mediation or arbitration, there is forms of mediation. It can be mid-up or up-mid. So traditional Islamic mediation has this type of feature. Therefore, the mediator decision may be appealed against. That means if you are not satisfied with his decision, you can take it up, which we will call appeal. Therefore, this mediation under the Sharia is very important because it helps the people to resolve their own dispute either via negotiation, that means between themselves or among themselves, or as a result of the help or assistance of a third party. So in that circumstances, it will become so simple. But in case of tahkim, usually it's used in the case of inheritance or violation of trust or land dispute and the juvenile crime or child abuse. So in these circumstances, the parties themselves, they can resolve their own issue considering the nature of the case. These are the elements of Islamic or traditional Islamic mediation. Therefore, Islamic mediation can be used as a preventive tool. You can use it to make sure that peace exists within the community. Islamic mediation can be used as an excellent preventive tool, and they can be used effectively to resolve problems or to stop problems from escalating and becoming worse. So these are the most important issues that help Islamic mediation to become acceptable among the people. So the most important thing is a fair balance in choice of mediator. Choosing mediator is very important. But the most important things under the Sharia is to know, is the person to appoint, is he knowledgeable on how to resolve issues among the disputant, or is he not knowledgeable? If he is knowledgeable, fine and good. That is why we are having this lecture, in order to equip you with what? With the knowledge, to know the types of mediation, and to know which issue and which issue can be resolved via sulhu, via tahkim, via mutasib, or any other issues. Therefore, parties can appoint the most eldest people within that community, can appoint their neighbors, to sit in any particular place to resolve their misunderstanding amicably. At this juncture, it is very important to understand that confidentiality is mandatory, because at times, this mediation, the reason why the parties want to mediate, because they don't want to disclose the issue to the public. Once a mediator cannot be or cannot keep the information within or among the parties, that is very unethical. He is not deserved to be a mediator. Why? Because if he is to disclose the issues or the dispute to other people, another dispute might emanate. Therefore, a mediator must understand confidentiality is mandatory. Apart being a neutral in that case. And the religion of Islam disallow a mediator to disclose any information to any other third party without the consent of the parties. You can only disclose it in order to help them understand the issues. For example, being a mediator, and you have a lot of cases that you settle. You can give them some information with regard to a particular case for them to understand the implication or of their refusal to amicably settle the issue. So the general element of Islamic mediation. Number one, can be used as a preventive tool. Fair balance in choice of mediator. Mediator must be neutral. Mediation process is consensual. Why it is consensual? The parties must agree, because the decision of the mediator is not mandatory, it's not binding on the parties, unless if they sign, they agree. So from there, no one can come back and say, no, I didn't accept. No, you must accept it. Else the other party can take it to the court, and the court must take it as its consent judgment, and they must enforce it against the refusal party. Then confidentiality or mediation process is flexible. The reason why it is flexible, when you start the mediation, it will end with arbitration. It can end at conciliation, or it may be even negotiation. That's why we say it is flexible. Confidentiality should be maintained. You see, you must maintain the confidentiality, as the confidentiality is very important. Then Islamic mediation is facilitative in nature. It's facilitative. It's facilitative. You are to facilitate. You are to assist. You are to help for the parties themselves to come with their own recommendation. To give order or to impose a recommendation on the parties. Just you have to facilitate. Tell them, for example, with regard to, for example, let's take example of marriage, dispute between the two couples. You can facilitate by telling her, because you have some children, why can't you exercise patience and look into the children? You can forgive him, because failure of the husband to maintain his wife and the children, exactly, he is denying her right. But if you exercise patience, as the husband undertakes to continue maintaining you and your children, why can't you go back? You see, now you are facilitating, you are suggesting. From there, the wife may decide, okay, no problem. I will go back, but I'll give him 3 months. If he maintain, or if you continue giving us our food and other things, no problem. But after 3 months, I will not agree. So this is a type of facilitation. But don't give command, don't give order. And you can even talk to the husband. Your wife is loving you. She loves you well. Why? Because of the children. Why can't you try as much as you can? When you get money, come and give her, so that it will prepare food for you and your children. You see, now it's like you are facilitating. You are encouraging him. So that's why we say Islamic mediation is facilitative in nature. Then mutual respect is at the center of Islamic mediation. Therefore, you must respect the mediator, because our concern here is for the mediator. Then this is public policy is respected. The reason why we are saying public policy is respected, even under the Sharia, there are some cases that are not allowed to be mediated, because cases are divided into three, or dispute are divided into three. No.
Mr. Abubakar, can you hear me? Abubakar, can you hear me? Mr. Abubakar, can you hear me?
I can hear you. Yes,
Okay.
I can hear you.
Okay, can you conclude?
Yes, I'm about to conclude. Therefore, there are three types of rights, or there are three types of dispute. Number one, dispute that exists that touches the right of individuals alone. This one can be mediated. Secondly, dispute that touches the right of human being and the right of Allah. Also, this one can be mediated. The last one, which is the third one, dispute that touches the right of Allah alone. This one cannot mediate between the parties. Therefore, in these circumstances, we should understand and note that we should not mediate over an issue that a public policy is made. For example, like an illegal contract is not allowed. Any narcotic or hard drugs, you cannot mediate over it. But a dispute between human beings that emanate as a result of marriage, that result as a result of any civil transactions, that one is allowed under the Sharia. Even though under the Sharia, there are some cases that can be even mediate between the disputant parties. In case of murder, if a member of a particular family is killed by a member of another particular family, in that circumstances, the member of the particular family that their member was killed can come and negotiate to collect compensation. So in these circumstances, we can understand that mediation is very important because it can touches the right we under the public bodies will not tolerate it. So that is the most important issue. So let's quickly discuss some issues that touches the mediator. The mediator must be skillful. Apart from being knowledgeable, can identify clearly the issue, the dispute between the parties. He must be skillful. Number one skill is communication skill. He must know which word is he use, the word that he can use to convince the parties to agree with him. Secondly, the mediator must know how to facilitate. That facilitation is very important. And he must be skillful to make sure that to show to the parties that he is impartial. Then thirdly, he must be a very important person that is respected within the community. So these are the skills that the mediator must possess. The last one is listening skill. The mediator must have a skill, must exercise patience to understand, to allow the parties to narrate their grievances, to narrate their misunderstanding, because via that listening skill, he will understand the problem and he will come up with a solution. Respected elder, for example, an mediation, like me now, I mediate more than over 1,000 cases that involves life under the Sharia. So this is very important part or member of a professional body that are using ADR in order to mediate. So these are most important role of mediators or skills that a mediator must possess to enable him to at least resolve the issue. Then the last aspect of this lecture is, can you generate money from mediation, from arbitration, from negotiation, or we can say from sulh under the Sharia, from tahkim under the Sharia, from muhtasib under the Sharia. Sincerely speaking, mediation under the Sharia, 99% you cannot get money. But the other 0.09 get money. For example, in case of inheritance, when somebody dies and you want to distribute that property and they agree, they appoint you as a mediator or as an arbiter to resolve that issue. When you are able to mediate and distribute that property among the heirs of the deceased, you will get your 5%, your 10%, depending on the nature of negotiation between you as mediator and the family members. And if you are lucky, the deceased left behind huge amount of money or his estate is huge, you can get a lot of money out of it. Also, in case of, because under Sharia, in murder case or in any case that involves life, if you are able to mediate, maybe the other party will be compensated. that compensation, it will help you, you can get its percentage. Because it can be 10 million, it can be 20 million, and it can be even 100 million. So that amount of money is very important. If you can get 5% of it or 10% of it, depending on your negotiation, that amount of money, it suffices you to get which amount of money. So these are the remaining aspects that is very fundamental, because this kind of mediation under the Sharia, you cannot make money at once. But once you are recognized and you are well established in the mediation of get money at times, and that money, when you get it once, you will be able to make a huge amount of money out of that mediation. So the role of mediator is very important, and that mediator must try as much as he can to facilitate and make sure that the parties achieve their own goals in a
It's Ibrahim. Mr. Abubakar, can you hear me? Okay. Thank you very much, Mr. Abubakar, for that wonderful presentation. Do we have any question? One or two questions? Okay, Kushi, please quickly ask the question.
Okay. Good afternoon, sir. I wanted to know if he's trying to say that in Islamic mediation, a mediator is not supposed to earn anything at all, but rather his services are supposed to be free of charge, if I get him correctly.
Abubakar, did you hear our question? Mr. Abubakar. Okay, you are muted. Okay, I don't know. Mr. Abubakar, can you hear me? Mr. Abubakar, can you hear me? Mr. Abubakar. Okay. Well, I will say thank you very much for that wonderful session. If you have questions, you can drop it on the chat box, and then I know. Okay, Abubakar, are you speaking through this device? Okay, so you can drop your question on the chat box. Kindly drop your question on the chat box. One of our facilitators is around, and the other one will soon join us so that we'll commence the next session, and then after which you can take your break. So you can just stand up and stretch yourself a bit so that your blood will flow through your body. Abubakar, can you hear me? It's Abubakar.
I can hear you.
Okay, please, can you attempt the question? Okay, let me, Kushi has asked a question, and I see Nimnan. Okay, so ask again, and Nimnan, after which Nimnan will ask quickly so that we can go to the next session. One of our facilitators is here, Miss Christiana. You're welcome, ma. We're happy to have you.
Hello, hello.
Hello. Yeah.
Hello.
Thank you. Yeah, you're welcome, ma. We just want to round up. Mr. Jeff will soon join us, and then we'll proceed, please.
Okay.
Thank you very much. Okay, Bushi, can you ask the question quickly?
I was saying that, does it mean that in Islamic mediation, a mediator is not supposed to be paid or is not entitled to any compensation?
Okay, you get that, right, Mr. Abubakar?
Yeah, I get it.
Okay, Nimnan,
get
ask the question so that I can answer it at once. Nimnan, Mr. Yes.
Yes. You made mention of 4 methods, 4 ways of mediation under Islamic law. And you mentioned sulhu, takim, mustashib, and fatwa, 4 of them. Then later on, you said there are 2 types of mediation under Sharia mediation. And you made mention of traditional Islamic mediation and then modern Islamic mediation. Yeah. Can you reconcile the methods, the 4 ones you mentioned earlier on, these 2 second ones that you mentioned? Can you reconcile them, please?
Yes, you know, in traditional Islamic mediation, in that one, they used to go and meet the elders or those that are knowledgeable in the area, and they are skillful in the area, and they are not looking for anything rather than to resolve the issue because they are the leaders or they are the elders in that particular community. You understand? And in modern Islamic mediation, you will see a center where somebody who is knowledgeable will go and have his own center. If you are interested, you are the one by yourself. You come and fill some forms for him to pay him. You understand? And especially it involves some transactions, because now you will see there's a dispute between 2 Muslims with regard to a particular transaction. that involves huge amount of money. In that modern Islamic mediation, you go to the center, you will fill forms. You are the one that you submit yourself. But notwithstanding is they submitted themselves to that center, that particular issue, you must be a facilitator. You help them to make sure that they resolve that particular issue. That's why we are saying we have traditional Islamic mediation. They don't ask for the money. They don't ask for the money. And even for the modern Islamic mediation, you will see most of the mediation is free of charge. Very few of the other mediation that involves money. In that particular one, you will be paid. I have answered the two questions in this.
You have answered, but I want it's actually the clarification that I want to get.
Which clarification? Be specific. Hello?
Classification.
Classification of this Islamic traditional mediation and the modern Islamic mediation.
The first 4 types, and I mentioned them. So can we call that traditional Islamic mediation, modern Islamic mediation? Is it, do you call it not like types, but like avenues? Like here, is it the avenue to settle the 4 types of Islamic mediation?
Okay,
those are the clarification I want to get very well.
Okay, sorry, please. I think you can just drop that question on the chat box, and then we are going to reach out to Abubakar will be here to attend to them, so that we can attend to our speaker all the way from Cyprus. She has been here with us. And I thought Mr. Jeff will join in quickly, but I think let's give her the opportunity to make her presentation before Mr. Jeff comes in. So drop the question on the chat box, and then we are going to forward it. He will be here. You will see your question. He will respond to it, and then we can call him to also respond to it. So having said so, thank you very much, Ms. Christiana, for joining us this afternoon. It is afternoon here, hot afternoon, and we're very happy to have you. Briefly about Ms. Christiana. Ms. Christiana is someone you want to meet. Here is a brief about her. She is the president of International Association of Mediators and Poly Experts. She is an international lawyer. She is a psychologist, profiler. She's an international accredited mediator by the International Mediation Institute. She is a member of the ICC, WMO, AAIL, YWIPO, IAML, and she consults. She's a consul general and international trainer. She practices. Her practices is international in nature, and she practices in India, in Cyprus, among several other countries. She's a certified mediator. She's a peacemaker. She's a certified intercultural negotiator. She's the vice editor of and representative of the International Project Mediation Theater, scientific editor of the International Brazilian Institute of Mediation, and she's a law Ibramak. She's a PhD researcher, and we are honored to have her this afternoon to speak to us on our area of specialty. So please join me to welcome Ms. Christiana to talk to us on culture in mediation. Over to you, Christiana.
Thanks a lot. Thanks a lot. Please, could you please share my presentation if it's possible?
Yeah, sure. Certainly.
Yes. And before you do that, I want to again thanks all of you. You're really amazing. As I like to say, all my students as well. That person is great who came to solve all conflicts through mediation or IDR tools. And I want to greet, I don't know, somewhere it's morning, afternoon. It's a really pleasure to be here today to discuss a topic that is increasingly important in our globalized world. So culture in idea and differences in cultural languages.
Okay, so here we go.
Okay, perfect. So, thanks a lot, thanks a lot. So this is how I made this picture in order you understand the culture differences in IDR. So I basically am working in CIC countries, in CIS countries and Cyprus in Europe. But because I am a researcher, PhD researcher, we have too much I am investigating too much, especially in the culture, as I am a polyculture mediator. So let's go to move. I want just let you know that it is not special, just simply theoretical. I want your feedback, and I have some roles for you. So at the end of my speech, I want you and just dive in this culture differences. So it will be some role case playing, if you are never mind. So let's start from the first. As we know that I do believe my colleagues previously explained what IDR, and this is an umbrella term that includes various methods such as mediation, arbitration, and negotiation. So briefly, I will say that understanding of IDR is too important before I go to the specific niche as where I found myself as a culture niche. What we are using in IDR is what the main is we're resolving conflicts outside of the courtroom. From 3 of these IDR tools, I'm using more mediation. I will be honest with you, mediation and after negotiation, but the arbitration I'm giving to my lawyer friends to use. So, and today's lecture will explore the profound impacts of culture of IDR. So we'll dive into the ways the culture differences and the manifest and communication. We will discuss the role of cultures and competencies in successful IDR. So, and we will I will provide practical stages for navigating the differences in real world scenarios. By the end of this lecture, I hope you will have a deeper understanding of why culture is not just a backdrop in IDR, but a central element that can determine the outcome of a dispute. So understanding of IDRs is, as we all know, if I do believe I will just briefly basically slide the mediation, the process where a neutral third party facilitates in conversation between the dispute parties to help them reach a mutually acceptable agreement. Arbitration is known as a process and neutral third party not as an arbitrator. Here's arguments and evidences from both sides and then makes a binding decision. So negotiation is a direct dialogue between parties aimed at reaching an agreement without the involvement of a third party. Shortly, what kind of benefits we have? Each of these methods offers different advantages, such as speed, cost effectiveness, confidentiality, not all of them, especially mediation, and the preservation of relationship. However, these benefits can only be fully realized in the culture dimensions of the parties involved are taken into account. This is too much important. Without this, what might seem like a straightforward dispute resolution process can quickly become complicated. This is from my practice. So we're leading to misunderstanding, will lead this way to misunderstanding, and in some cases, failing negotiation. What is the role of culture in IDR? Can you just show the second slide, please? So now that we have an overview shortly, briefly, I say that about the idea, let's explore the concept of the culture and its role in IDR process. The culture can be understood as a collective programming of the mind that distinguishes the members of one group or categories of people from others. It encompasses a wide range of the elements, including values, beliefs, norms, customs and behaviors, and much more. These culture elements shape how we view the world. We are all unique, all, each of you. Not to mention we are different countries, different nationalities, different the communities, we're from different families, but each of you, because I don't see all of you, they're just the clothes and the pictures, we are all unique. So how we interact with others is unique, and how we approach conflicts is all, or we are all different. In the context of IDR, the culture influences. I will show this several aspects. So, perception of the conflict is number one. I guess we move. We'll move. I guess it's previous slide. Yeah. In some culture conflict, it's seen as a normal part of life and address it directly. In other conflicts, it's viewed like it's something to be avoided, and
Christiana, is this the slide?
Yes. No. It's the second one. I'm speaking now about the second one. There's a role of the culture in IDR. Yeah. We are now perception of the conflict. Thanks a lot. So in other conflicts, we just we view as something to be avoided, and there may be preferences for indirect approaches to resolution. This is what we can say about the perception of the conflict. Moving forward about the communication styles, as we will discuss in more detail shortly, communication types and varies greatly across culture. They're going line by line. What is considered polite and respectful in one culture may be seen as rude or rude and not acceptable in another. The third one, decision-making process. The culture norms how decisions are made. Some cultures emphasize the collective decision-making. This is this is a practice. This is from practice and research. So, but while others prioritize individual and autonomy. Let me give you example. From the Caucasus region, specifically Georgia and Armenia. In this culture, which are deeply influenced by the historical context and traditional values, the honor and reputation play crucial role. This is number one. And in how conflicts are perceived and resolved. It's coming from these two important values. In both Georgia and Armenia, family and community ties are extremely strong, and decisions are often made with the input of extended family members or respected community elders. For instance, imagine a business dispute between a Georgian entrepreneur and an Armenian business partner. In both cultures, there's a strong emphasis on preserving the relationship and avoiding public conflict. A direct confrontation might be avoided, with both parties preferring to engage in behind-the-scenes negotiation involving trusted intermediaries, as we are mediators. The concept of the patronage is also significant in the region, where influential figures or community leaders may be brought in to mediate the dispute. So often, with an approach that balances from legal consideration with traditions and the culturally grounded methods of conflict resolution might be more close to this culture, If you know geographically, the Georgia and Armenia are neighbors. So, but they can be neighbors, they can have some similarities, but they are different. If a mediator from the Western context, where dialogue, negotiation, and individual decision-making are more common, where to approach disputes without the cultural awareness, they might misinterpret the indirect communication and involvement of the third parties as a lack of the transparency or commitment to resolve this issue. So, however, understanding these culture dynamics is crucial for effective facilitating and a resolution that is acceptable for both parties. But without knowing the culture background, the culture of each representative of this, if it's of course the high level public mediation disputes, so you have to come across with differences informal way and informal way. Anyway, the most of them, they use old-fashioned techniques. I will just mention that some of the mediators are the community leaders, because in Georgia and Armenia, they are multi-nation countries, and they have in the capital, for example, in Georgia and Tbilisi, all religion considered in the square, public square, and you can see all religion representatives, and they are living in a peace. Imagine this, where I can say that they're building communication, and the leaders of these communities, they are really professional mediators, intermediaries. We are moving forward, and I want to show and explain to you the cultural differences in communications. We are moving in the next slide, please. Yeah, we are here. Let's take a closer look at communication. This, I guess, a key component of any idea process. I do believe you all agree with me. Communication styles are heavily influenced by the culture, and understanding these differences is crucial for anyone involved in idea. First, high context, low context culture. So high context versus low context culture. First, high context culture, as we want to make the example, we change it to Georgia, Armenia, these countries, and Cyprus as well. And you know the Cyprus, where I'm now located, I'm living in Cyprus. The Cyprus is an island, and I will tell you something. All people or nations they consider it on the island, we call island people. They have constantly differing culture. The Mediterranean people, we're closer to the seas or oceans, they have constantly differing culture. The high constant culture in these example countries rely heavily on non-verbal cues, context, and the relationship between communicators. Much of the communication is implicit, and understanding requires reading between the lines. So you have to approach yourself to live between lines. So you have to get the meaning between the communication. But it's not coming straight, my dears. It's coming by practice. Unfortunately, you can study in 1 hour or even 1 day, in 1 month. Everything is coming by practice. Second one is low context culture. I will say about the United States, Germany, Scandinavian countries. So they are empathizing that direct, explicit communication, where the message is conveyed primarily through words. Direct, straight. This is what, in order to understand low and high constant cultures. Miscommunication can easily occur when parties from these two types of culture interact. Just imagine, a mediator must be able to bridge this gap, interpreting the underlying and messages and facilitating understanding between these two different low and high culture differences. There where we call experience and expertise. The young mediator, young polyculture mediator could not handle straight away without co-mediating. We will speak about that a bit later, where I will give you some tips from the beginning if you want to choose this niche. So the second one, the direct versus indirect communications. I will, for example, the countries, Americans, Australians, they are direct communications. They use these tools. So they tend to be straightforward, valuing clarity and directness. So they might see indirect communication as evasive or deceptive. So if you are not direct, they just will, so it's coming, I will slow down, I will make I will feedback, I will just observe. So this is a failure of negotiation. Indirect communication. Many cultures in Caucasian and CIC countries and Mediterranean countries use a more nuanced approach before you will open the door and come to the mediation session or in this room. They will investigate. The first mediator should to investigate who is coming and where what is left unsaid can be important and what said is important. Sometimes is what not unsaid is much important than said. So here a mediator is like a lizard, is like a magician. You have to guess where the between these lines, what kind of meaning this from these countries the parties came to say to him, to explain in mediation session. The third is non-verbal communication. I don't see all of your eyes, but don't be scared. It's scary from the beginning, but when you are just deep in this niche, you can't see yourself just simple family mediator or business mediator, because as a polyculture mediator, you can handle, after all this practice, you will handle any hard cases, whatever you will just take, a family and business or whatever. The third, non-verbal communication. Gestures. As we know, verbal we have 20%, non-verbal we have 80%, because I have time to explain to you. I was my students, I explain, of course, because we have a special course, I'm explaining what exactly in communications that we use more gestures than verbality. The verbal tools we use less wide. As a mediator, we are using active listening more, but the professional parties, negotiators, the same. If they're really sharks in negotiations, they will come and they will step back, they more listen, and they use non-verbal, they use gestures, they show they have hand gestures, body languages, and facial expressions, emotions, very significant, they are all these differences in the gestures across the culture. For instance, in Georgia, not might indicate agreement, but in some CIS countries, the same gesture could be used like a convey understanding without necessarily agreeing. Eye contact. In some cultures, maintaining eye contact is seen as a sign of confidence and honesty, while in other countries, it can be viewed as a disrespectful or confrontational. It's really, I have been in Dubai. I will just slowly, I want to show you practice. And I had eye contact with some locals, and because I was practicing, I went to the Dubai and practice their culture. As I understood that it was really, he felt himself disrespectful when I look at her, and she says to me, "Why you are looking at my eyes? What I did so bad that you are looking in my eyes?" So I have been in a shock, because for me, it's honest, I was smiling because I liked her actually. She was so beautiful. And I wanted to ask her where she bought this mandala, nice, beautiful. So she understood, she felt something confrontational, for something disrespectful. There is too much sensitive. Please you have to study before interact with eye contact. In Armenia, Prolonged eye contact might be avoided as a sign of respect, because when you look at this Armenian, this is cultural differences. If you look straight, they will like it. They will concept that you respect by looking straight in the eyes. You could not lie, because actually liar, but this is a different topic. They could not look at the straight. Only 1 or 2 people can lie and look at the straight, but they are spies and they are working or other, how to say, special forces. So they study how to professional to lie and look direct into the eyes. Silence, we are moving. Silence. Silence can have different meaning across the culture. In Georgian, Armenian, Cyprus, silence in a conversation can signify respect, contemplation, or even some subtle disagreement. Whereas in Western cultures, it might be interpreted as awkwardness or a lack of interest. So you see, the geographical, cultural differences that play crucial role. You have to investigate, you have to study about the silence, eye contact, gestures before start any mediation session. We're moving forward, interactive segments. Let's consider hypothetical scenario. Imagine a negotiation between a company from Cyprus and business partner from Russia. The Cypriot negotiator feels that Russian counterpart is not being transparent enough, while the Russian negotiator thinks that the Cypriot is being too direct and not showing enough respect for the formalities and hierarchy. What cultural factors are at play here? How might a mediator help bridge this gap? How do you think? I want to make a bit just relax between I will continue. How do you think? Cypriot and Russian businessmen, negotiators, they meet with each other. Somebody is working or you don't know all the culture. How do you think they just answer? I want to listen if somebody is at least practicing in culture. Okay, I will move forward. I see the group is a bit aware.
Okay.
Yes, I'm listening.
All right. My assumption is the person from Cyprus,
yes,
would have high cultural affiliation than somebody from Russia who has a low cultural affiliation. So when you're discussing with somebody from Russia as an individual, you're satisfied with it. But when you come to maybe Cyprus, you might look at the family or relationship and so many other things like that as well too. And then I'll look at Russia as maybe if you're discussing with the Russian, maybe the discussion might be direct, and maybe that of Cyprus might not be too direct. And I'll look at when it comes to communication from Russia, it could be the gestures might not be too prominent. It might be more in words than gestures. And silence and eye contact might not be the dominant factors, but the direct communication might be more dominant in discussion with them. Thank you.
Thanks a lot. Niman, you are amazing. I guess you have some experience by communicating with the Russian because you explain the Russians very good.
Thank you so much.
I will say to you, because I have experience and I am scientific editor, vice editor of the scientific the university in Russia as well, and I know them from too good. So I was experiencing. I learned about the Russian negotiations. They are direct. You are right. They're direct. They try to use eye contact because they want to see if the person is honest with them and if they are lying to them. Because if you know from the past and historical, but I'm moving now slowly about the building trust. We're moving. I will say that for them, building trust in negotiation is just like better to have a trust than money. For them, it's everything, because this country, let's face it, this country is like is a military background. From history, you see the too much wars and the character of these people negotiation. You cannot change. This is coming from geographical and historical values. Russians are strict, they are cold, and they can leave anytime when they want, without interrupting and without sorry. This is how they are negotiating. Not all of them. This is really clear, just Russian ones who they are never left, they see or they have been outside, or the Russians in Europe, they are constantly different. We'll speak about the geographic nuances, and but clear Russian gestures, eye contact. You are correct. The Cypriots, they are more indirect. They are so flexible. They are they like to give between lines the meaning of negotiation. And for Cypriots, it's siesta number one. They like to have negotiation in the not formal way, informal way. They will invite you to the coffee shop to have negotiation, not in office. So most of them they are using different concepts. Thanks you very much. I guess it was a bit make you relax, and we did in a practice. So I'm moving forward. Active listening. So active listening, and we just. So I think direct and non-verbal communication will finish. Please, could you share in next one? Are you share it? Yes. Cultural sensitivity in IDR. Let's go. I gave you these differences. The cultural sensitivity is a vital skill for anyone involved in IDR. Cultural competence allowed mediators and negotiators to navigate the complexities of cross-cultural disputes effectively. Here are some stages to enhance cultural sensitivity in IDR. The first one is research and preparation. Always, before entering into any IDR process, take the time to learn about the culture, backgrounds of the parties involved, understanding their culture norms, values, customs, and communication style, because they are geographically divided communication style that with Niman mentioned now. It really can help you anticipate potential issues and tailor your approach accordingly. So we're moving forward to the active listening. I guess it's number one in the mediation session, because we listen between lines, underlines, and above and down. In all ears, we are mediators. So practice active listening to understand not just what is being said, but also what might be implied. But we have to pay attention to nonverbal cues and be open to ask clarifying question if someone's is unclear. Mostly unclear because the parties coming to the table, they don't know what they want. Mostly, it's from my practice, 75%. They're coming with one position, and on the table we see 25. So what we are doing, we have to move forward in order to build a trust, right? Trust is a crucial in idea process, and building trust across culture, especially northern countries with high, low, and low cultural differences, requires respect. Patience is number one for me. And sometimes a willingness to adapt your approach. For example, in culture where the relationship are valued over transactions, such as in Armenia or Georgia and Cyprus, taking the time to establish a personal contact can be more important than jumping straight into negotiation. For them to have a small talk, oh my God, it was a pleasure to see you. Oh, it was a long way, yes. Oh, you have a beautiful picture. Oh, really? Yes, it's the copy of Leonardo da Vinci. Which one? Yes, of course. So sometimes to be prepared to understand which kind of culture is in front of you, you just catch and keep closer in order to figure out, okay, with these people, I can take, I can build trust, I can mediate. Flexibility and adaptation. Be prepared to adapt your strategies based on the cultural context. For example, you are mediating between parties from different culture, you might need to balance direct and indirect communication styles. You have to be flexible. At the time you see they are going between lines, somebody going direct, you have to use the flexibility at that time. And you just you have to ensure that both sides feel heard and understood. Inclusive practices. I will speak more about inclusive practices. So make a conscious effort to ensure that all voices are heard and respected in the idea process. So this might involve adjusting the process to accommodate the culture norms, such involving elders or respected community figures in the decision-making process, which is common in Jordan, Armenian, and as well in Cyprus, Mediterranean countries. I want to pay more attention to the practices, inclusivist practices. We are here some ways to foster inclusivity. So this involves the creating an environment where diverse perspectives are recognized and integrated into the decision-making process. So first, language accommodation. Second, cultural advisors or co-mediators. adjusting the process to cultural norms, creating a safe and neutral environment, acknowledging and valuing diversity, and promoting equality and fairness. Now, one by one, language. If the parties involving speak different languages, providing translation services or conducting the entire process in a neutral language can help ensure that everyone can participate fully, and they will feel themselves more respected. Even when this is a common language, be mindful of cultural idioms or slangs and jargon that might not translate the well. At the same time, I want to mention Nigerian accent, right? You know, between different, even on African continent, between different African countries, they have different accent and dialect. Am I right?
Correct.
Yes. So the mediator, you maybe Niman is a mediator, and somebody came from South African Johannesburg. Johannesburg accent, I listened because my member association and my partner from South African Johannesburg. And when she started to speak with me with dialect, I listened because I have a Nigerian friends as well. It's constantly different. And that time, we have sometimes not only dialects, idioms and slang. Most of the culture, they're using slangs. Like we can say about Americans and English pronunciation. And Australian as well is constantly different. New Zealand as well. So there we approach the language accommodations. Even where there's a common language, we have to be sure we'll understand everything what's said between parties. Cultural advisors or co-mediators. In some cases, it may be beneficial to involve a cultural advisor or co-mediator. So here we go. From the beginning, I said that if you are aware and you don't know about this culture, about this nationality, you just need help, but somebody choose you as a mediator, you can always find cultural advisor or expert in this culture, or co-mediator, your colleague from this country who is familiar with this cultural backgrounds of the parties involved. It's not a purpose, some of the mediators, I understand, we have to monetize our job, but sometimes your goodwill, your name, and your professional level you have better than just you will take the case and you understand that you don't understand the culture. You can't negotiate. You can't just, it's like a mess and you will not really mediate. So better to split, but you will keep your name. And the people will value that it's not only everything about money. You will gain money, but your name is everything. This person can provide you insights which you will not read in the books, really. And they have a cultural nuances and will help you really bridge and gaps in understanding. We're moving and adjusting the process of culture norms. Be willing to modify the structure of idea process to accommodate culture norms. For example, in cultures where hierarchy is important, it may be necessary to allow for more differences to senior members of the group. In collective culture, you might need to facilitate consensus building a broader group rather than focusing on individual decision makers. This is all nuances. Creating a safe and neutral environment. I will say that neutrality is one of the sensitive and crucial, and because all of the clients think, oh, you're impartial, okay, and you won't, I will believe, but they're not using verbal. By eyes, you can see that there is no trust. They don't think that you are neutral. They don't think that you are impartial, but you have to show them. You have to fight for their trust and build this trust. Ensure that the physical virtual space where the idea process take place is neutral and comfortable for all parties. This includes being aware of seating arrangement, layout of the rooms, and even the timing of session to respect balances between cultural customs and such as prayer times or meal breaks. And the name and surnames, you have to ask how they would like to, because in some Muslim countries, the spelling 5 structure of the names, you can say, oh, hello, Muhammad, or hello, how I can say you, but Muhammad. No, you have to ask, and there where you will show respect. And whereas between Muslim and Christian, they have some business issue. So at that time, or the gender, because a gender aspect is too much important. If you're a man mediator and the one party is a female and man, first you have to ask, am a woman. If you are a woman, you have to ask men. It's not about just in order to show there is a balance. But asking the man, you the same time turn your face and just showing the balance that it's not just because I want to respect the man, but at the same time you have to ask 2 times better. Nothing will be with you, but in this way you will show neutrality and you will show respect. Acknowledging and valuing diversity. So make it clear from the outside that diverse perspectives are not only welcome, but considered and assessed in finding a resolution. Encourage parties to share their culture viewpoints and how they may impact their approach to the disputes. And promoting equality and fairness. Strive to maintain a balance, as I said, of power between the parties. In cross-cultural IDR, one party may feel disadvantaged due to language barriers or unfamiliarity with the process. It's important to recognize these imbalances and take steps to level to plaintiff field, to play this field, and such allowing them extra time or translation or explanation of the complaint concept. So that time when you put them all in the frame of time, it might be disrespect as well. My colleagues sometimes misunderstand. Why? If I say 1:45, we have the station have to be 1:45. We have to respect our time. As a culture, for the culture mediator, is not acceptable because there is disrespect. We have to value religion, cultures, a lot of aspects. It's just not business negotiation. We are diving in too much nuances. And the point I want to, I guess the role play I will leave now. I have some role plays for you. So I want to make a conclusion. I want to wrap up today's, let's recap that the key points, what we gained today about the culture. After I will move to the role plays, will be interesting. So what we had. The culture plays a crucial role in an IDR, yes, by influencing how disputes are perceived, how communication is conducted, and how decisions are made. For example, in Caucasian regions, culture values such as honor, respect, community involvement, and indirect communication heavily influenced the dispute resolution process. So understanding the culture differences, especially in communication styles, is essential for effective IDR. Recognizing whether a culture is high context or low context, direct or indirect, can help avoid misunderstanding. And the cultural sensitivity and inclusivity are vital for mediators and negotiators. By researching culture backgrounds, practicing active listening, building trust, employing inclusive practice, emotional intelligence. We have too much intelligence, but here I just want to give you basic one. IDR professionals can facilitate more effective and fair resolution. In our discussion today, we saw how culture nuances from regions like Georgia, Armenia, Cyprus, Middle East countries can shape IDR process. And as future leaders and professionals or future mediators, facilitators, arbitrators, negotiators in international relations, law, business, or family, or ability, it just give you ability to navigate cross-culture interaction and it will be like a significant asset for you. These skills are not just about resolving conflicts. They are about fostering understanding, building bridges between countries, between cultures, between peoples, and create sustainable solution in an increasingly in connection and this interconnection between globally. So I encourage you to continue exploring this niche as a polyculture mediator. Maybe somebody like it, maybe because it's difficult, because cultural competence is not only skill, but necessary in our diverse globalist society. We use it every day. It's the more you use the cultural differences, know all these tools and nuances. You use emotional intelligence. You use now we'll use artificial intelligence, but all these intelligences will build in you professional mediator or IDR specialist. Thank you for your attention today. I'm happy to answer any question you may have or discuss about of these points, but before you can write down in a chat box about your questions. And I want to role play. If I have a time, I will ask if I have a time. Just need 10 minutes to play this role play.
All right, thank you very much, Christiana, for that wonderful session. We really appreciate you for coming on straight from court and giving the participants a very wonderful presentation on how important culture is in mediation. Mr. Jeff is here. So grateful for creating time to join us this early morning. I apologize for the mix-up in time. We're using West African time, and then the time we couldn't get it right. So thank you so much. Now, let me hand over to Mr. Jeff.
Okay.
Mr. Jeff to give us another crucial perspective on on culture in mediation. Mr. Jeff, briefly about him. Mr. Jeff is ranked in Chambers as Band 1 as one of the United States top mediators. He is a graduate of the Harvard Law School and the University of California, Berkeley, and he has been a full-time mediator for about 28 years now. He is an elected member of the American Law Institute. He has helped settle thousands of B2B cases, and principally, he specializes in the areas of intellectual property, insurance coverage, and legal and accounting malpractices. He specializes also in settling impossible to settle cases. And we cannot say how honored and happy we are to have you here. The person that reached out to you actually told me that you are her mentor, and we're actually glad and happy to have a mentor of a mentor with us. Mr. Jeff, please let's welcome Mr. Jeff, and over to you, sir.
Thank you, Nanchang. It's a delight to be here, and I greatly appreciate the invitation. And perhaps you could ask people to mute themselves. I hear some background noise coming in. Thank you. It's a great honor to be here, and well worth getting up very early to do it here in California. It's 6:30 in the morning, and I appreciate the opportunity to get my day off to a good start speaking with you here. So in speaking about culture, I first want to make clear the kind of work that I do. The kind of work that I do is mediation of litigated cases. So these are situations where litigation in the court system or in an arbitration is either pending or anticipated in the near future. So in the kinds of cases that I do, there are lawyers present, and lawyers representing the interests of their clients, of course. Clients also generally participate directly in the mediation. They're usually present physically if we're doing the mediation in person, or in these little Zoom boxes if we're doing it online, just as I see your names or images in these boxes that are on the screen right now. So those are the sorts of cases that I do. And they often have international aspects to them. In the world of insurance, there are oftentimes people in the United Kingdom or other countries representing insurance carriers. In intellectual property cases, patent cases particularly, we have people from various Asian countries, Beijing, Taiwan, Vietnam, many other places in the intellectual property situation. So there are people from all over the world. And in California, we have a very cosmopolitan population with people who were born in every country in the world living here in Southern California. So there's a lot of international situations in the mediations in which I work. So let's dig in and let's talk about culture, at least in the kinds of situations in which I find myself. First question I want to ask is, what do we mean by culture? Could mean a lot of different things. And the best working definition that I've heard of the word culture is the way we do things around here. That's the culture, the way we do things around here. But this creates as many questions as it answers, because when we talk about the way we do things around here, we then have to go on and ask, who are we and where is here. And it's complicated. I think it's complicated for each and every one of us. I'll just take myself as an example. I was born right here in Los Angeles, California, where I still live. So I'm an American. That's part of my culture. But that's not all there is to it. I'm also 68 years old. So I'm part of my generation, what's called the baby boomer generation here in the United States. And that culture can be very different from the culture of other Americans, the so-called millennials, Gen X, Gen Z, Gen Y, and all the rest of it. I grew up and have spent most of my life here in Los Angeles, and different regions of the United States, different cities have very different cultures. I went to law school in New England in the northeastern part of the United States, and things are in some regards similar, but in some regards very different there. In San Francisco, 450 or so miles north of Los Angeles, there are some cultural differences between San Francisco and Los Angeles, even though we're all in the state of California. I am male, so there are cultural aspects to that as well. As mentioned, I went to college at Berkeley and Harvard, and those universities have very different cultures. Each of them had some impact on me. It lasts to this day. So that's part of my culture. I'm Jewish. That's part of my culture. And even within that, we can't overgeneralize. We shouldn't overgeneralize because there are many different kinds of Judaism in the United States and certainly internationally. I have certain political views. That's part of my culture. I'm a parent. I have 3 children. Now I have 3 grandchildren. That has an influence on me. And that's part of culture as well and influences my thinking. I got married at a young age. I got divorced a few years ago, got remarried a couple of years ago. So being a married person, being a person who's been divorced, those things have impacts on me and are part of culture as well. And last but not least, I'm a lawyer. There's a culture of lawyering that is different than the culture of other trades and professions in society. So what I finally come up with is that everybody is an individual. And the question becomes, which of these many cultures or many impacts on me or any impact on any other participant in a mediation, what is the most salient? What's the most important in any given negotiation or mediation? Some aspects of the culture may not be salient or relevant at all. Others may be highly salient. How do we know? I don't really know in the moment which aspect of my culture, my upbringing, my background is most important to what I'm doing at any given moment. I can't really tell. So I do my best. And so I conclude that every mediation is cross-cultural to one degree or another. If there were no cross-cultural aspects, no different ways of thinking, well, we'd have far fewer disputes than we do. People have different ways of thinking about the same situation as a result, in part, of their culture, their upbringing, their background. And that's part of what gives rise to every conflict in which we find ourselves as mediators. So I try, admittedly imperfectly indeed, to deal with this in at least 2 ways in every situation in which I find myself as a mediator, remembering that every person deserves to be treated as an individual, as who they are. First, I remember that every mediation of a litigated case, anyway, has something to do with the rule of law, with the so-called best alternative to negotiated agreement, BATNA, and how that BATNA compares to the available deals which are being negotiated at the mediation. Now, I know that some biases will be slipping in, even if we're trying to talk about the rule of law and what is someone's best alternative to a negotiated agreement. That is how it would likely turn out in a court or arbitration. And yet, if we focus on the task for which we've been hired, to weigh the different alternatives and to help people choose among them, if we focus on the alternative being what would the rule of law provide and how would things likely, perhaps probably, come out if you were to take this all the way through a court or arbitration proceeding, well, that's one way that we try to deal, or at least I try to deal with the biases, cultural issues that may come up. Second, I try to focus on what I do have in common with everyone, every individual in the mediation. Not what makes us different, but what makes us similar? What can we discuss productively? What do we have in common? What are the cultures of which we both are a part? Even if we're from different countries, even if perhaps we speak different languages. Maybe we have children. Maybe we're married. Maybe we can chat a little bit and find out that we have some interests and tastes, whether it be in music or art or food or anything else in common. Maybe we both have a country we like to visit. I love visiting India. I've been there 3 times. That has an influence on me. And there are many things that we can discuss with people to show that there are things we have in common with them, and we can develop some chemistry and rapport, no matter how superficially we seem to be different from each other. I like my approach. It seems to work pretty well for me. And to me, it's better than what seems to me the most common alternative approach. The most common alternative approach, at least the way it's taught in mediation trainings, or was taught when I was trained as a mediator many years ago, seems to be a combination of trivialities of etiquette and gross stereotyping. For example, we are taught, mentioned in many mediation trainings in the United States, that people in certain Asian cultures have certain ways of holding business cards when presented with a business card. That is, they hold it in 2 hands in front of them and look at it studiously, and they're very careful and treat a business card with great honor and esteem. Okay, so is that the most important thing about dealing with people from Asian cultures? I'd hate to think so, but that's something that's frequently mentioned, or at least was frequently mentioned. It gets down to such things that seem trivial to me, etiquette points, as not crossing your legs in such a way that the soles of your shoes are visible to the people with whom you are speaking. Well, okay, but it seems to me that that's so trivial. It seems to me almost silly. And what I find is that people from other cultures are very likely to be very forgiving of small things like this, of breaches of etiquette, if you will. If a mediator comes to the situation with the right mindset, with an open mind, an open heart, and a willingness to help, if a mediator comes to the mediation with that mindset, then it tends to be reciprocated by the people with whom we're dealing with an attitude of forgiveness. Because after all, people in the mediation, they're maybe from other countries or other cultures, they know that I've got my ways and I've got my culture, just as they have their ways and they have their culture. And if we tend to come in with an attitude of constructive engagement, willingness to work with each other, collaborative mindset, we tend to be forgiving of these minor breaches of the etiquette of different countries. And let's face it, we're never going to know all of the points of etiquette of people from other cultures again, even people from our own country, people with other religions, people from other regions, people with other political views than we have. There may be a variety of etiquette points, even from people seemingly within our own culture, that we are breaching as well. And again, the attitude of forgiveness. In some cases where the salient cultures are too divergent from my set of cultures, I don't get hired at all. Those kind of cases don't come to me. And I get stereotyped as well as stereotyping of other people. So that's something that that as a mediator, you have to be prepared to deal with as well. And sometimes that's not such a bad thing. For example, if everybody is in a particular industry about which I know nothing, and there's a certain culture, well, I may not get hired for that case. Simple example is I get hired for very few matrimonial or divorce cases here in the United States, maybe once every 10 years. And that's because, other than my own divorce, I don't know very much about family law. And I really don't know the territory, don't know the culture of how those disputes commonly get resolved. I'm not that familiar with the law. I'm not all that familiar with the psychology of all that. And so I just don't get hired for those kinds of cases. Now, there are other cases where I think this sort of stereotyping may be a bad thing, because I may lose the chance to help people in situations where I think I can genuinely be effective and help them. On the other hand, stereotyping of me as a mediator may in part be a good thing, because it may create space for newer, younger mediators, mediators with less experience perhaps, but perhaps more familiarity with a particular culture, diverse mediators to break in and get some work. Now, another thing that helps in those cases where I do get selected is in the preparation process. Because in the cases where I work, almost always the parties are represented by lawyers. And there's a culture of lawyering, at least in the countries where, I'm dealing with people from the United States, Canada, England, United Kingdom, sometimes continental Europe, and sometimes there are parties from Asian countries, but by and large, the lawyers who are involved are from the United States, the United Kingdom, Canada, and sometimes other English-speaking countries, Australia, New Zealand, places like that, but rarely. And so there are some built-in commonalities of the culture of lawyering, and I try to use those to my advantage in the preparation process. It's very important to me, the way I practice, to prepare thoroughly for every mediation. So I ask people for mediation briefs at least a week, sometimes as long as 2 weeks. It's hard to get the briefs more in advance than that from people. So I get the briefs, I read them, and then I like to have Zoom calls or phone calls with people before the mediation, with the lawyers at least, because no matter how diverse culturally the clients may be, the lawyers and I have some elements in common, some cultural elements, the culture of lawyering. And in those calls, I find out about the other cultural differences which may exist. I probe for that. What do? Well, I ask open-ended questions. First question I'll generally ask a lawyer is, I've read your brief, and I'll recite some points to make it clear that I have read the brief. And then I'll ask, what else do I need to know to be most helpful to you on the mediation day? I like a good open-ended question like that. It gives the lawyers a lot of space to tell me whatever they think I may know, I may need to know. But what I really want to get to is the issues of the personalities and the people involved. Because those are things, particularly in terms of a lawyer's relationships with their own clients, that are not going to get put into writing. A lawyer's not going to put into writing, even in a brief stamped confidential 10 times, such things as, well, my client is a hothead, or my client is emotionally very tightly wound, very uptight about the situation. I'm having trouble communicating with my client. My client is so emotionally intense. I'm having trouble getting some of these logical points through to my client. No lawyer's going to put that in writing. There's some risk the client's going to see it and it would be terribly embarrassing. But if those are the real issues going on, well, I need to know about those. And if there's cultural issues down there, I need to know about those too. So I'll follow up with some other open-ended questions designed to get into the human factor. I'll typically ask questions such as, what are your expectations of me as a mediator? Because those can differ wildly from case to case. I'll ask, what are the challenges that we face? And sometimes these cultural issues will come out. And then I'll ask what I think is perhaps the most important question. Tell me about the personalities of the participants in the mediation, how people are getting along with each other, and what I need to know in those regards. And that question usually will get out some of these cultural elements. And I'll be able to ask, okay, you're telling me about your client. What are the things that I should avoid saying or doing with respect to this client? What are the things that I should be sure to say or do with respect to this client to try to build up some chemistry or rapport? Because as a mediator, I want to have chemistry and rapport with the client. Let's face it, at day's end, what a lot of lawyers call on a lot of mediators to do is to urge the client to pay a little more, take a little less, or do something else that's above and beyond the call of duty in order to make a deal and to reap all the long-run benefits of making the deal, reducing uncertainty, getting people's time back, not being distracted by lawsuit, eliminating the risk of an extreme result in the case, eliminating legal fees. Yes, that's true too. And busy lawyers, good lawyers don't mind you mentioning that. So yes, lawyers will count on us as mediators to try to get their clients to do a little extra at day's end. And to the extent that we can do things during the day, particularly at the beginning of the mediation day, to establish trust and confidence and rapport and chemistry with the clients, that really pays off at day's end. And in order to do all of those things at the beginning of the day that help us at day's end, proper preparation and talking to the lawyers about the individualities, the particularities of the personalities, characters, and cultures of their clients, doing all that in advance is critically important. I cannot stress how often the most important thing in a mediation, the biggest challenge seems to be the relationships between lawyers and their own clients. And sometimes there are serious cross-cultural elements there, even if the lawyer and the client are of the same race, the same ethnicity, the same sex or gender, the same nationality. Doesn't matter, because the culture of being a lawyer is in many ways different than the culture of being a client, particularly if the client is not experienced or sophisticated in the ways of litigation. This could be a consumer type plaintiff, someone who's involved in personal injury or employment matter, commonly here in the United States. It could even be a sophisticated business executive. Business executives who are very sophisticated in their own business, their own industry, but perhaps have not been involved in significant litigation before. So the culture, the way of being a lawyer who does nothing but get involved in disputes and conflicts and legal situations can be very different than the culture of being a client, unsophisticated, perhaps a first-timer in litigation of any magnitude. And so we have to deal with that cultural difference as well. Sometimes I say that the most important thing I do as a mediator is I help good lawyers break bad news to their own clients. And that is supporting a lawyer, oftentimes in a caucus, a private meeting, and ideally after a joint session, in terms of helping a client understand more fully with logic and emotion in better balance the options with which they're presented in that mediation. And sometimes a lawyer will tell me that they've been trying to talk to a client for a long time about tempering risk, not taking extreme risk, doing things, not at all selling out the client or letting the client down or failing to do the lawyer's job of being a loyal fiduciary and a zealous advocate. Rather, it's taking a hard look at the risks and not doing things, not taking risks that may be extreme or foolhardy. So how does that work? Sometimes you have a joint session, and if it's properly planned, you focus in on the issues that are truly keeping the parties apart in this case. And then in the caucus which follows, having a conversation with the lawyer in the presence of the client about the strengths and weaknesses of the situation, about the settlement options which may be reasonably available to the client that day, and in helping the client make the proper choices with reason and emotion both playing their proper role. Sometimes it doesn't take more than simply asking a lawyer, well, what do you think? What do you think are the right options or the best choices? What do you think? You think the pluses or the minuses outweigh each other? Having the lawyer talk about the options which are available to the client, and then simply reinforcing that, assuming that it deserves reinforcing, and almost always it does, and saying, I've heard your lawyer talk about these points, and I think your lawyer makes some good points here about what risks are reasonable, what risks are extreme, and what you perhaps ought to be considering as you decide whether to settle the case or not. I think your lawyer's making some very sound points. And I'll never say it if I don't think the lawyer is making sound points. My experience is that almost always the lawyers are doing a good job. They're well prepared. They're putting their clients' interests ahead of their own. They're not trying to drag cases out just for the purpose of making a fee. They're doing what's responsible. They're doing what's right as they see it by their clients. So I'll give you an example. I mentioned I do a lot of intellectual property cases. And sometimes we have a very interesting cross-cultural dynamic there where the lawyer is a lawyer and the client is an engineer or a scientist. And even if they're same race, same sex or gender, same ethnicity, same nationality, the way engineers think about things is in many cases a whole lot different than the way lawyers think about things. Engineers, scientists, they look at lawsuits in many ways the way they look at a math problem, a calculus problem. There's one right answer, and if you follow the steps, apply the rules to the facts, you get the answer. And lawsuits and settlements oftentimes don't really work that way. Things can go wrong in litigation in ways that they don't go wrong in math. You can apply all the rules and all the principles to the facts, and you may think that the right answer favors you, and you may still lose the case. Who among us has not seen the situation where a case that you think really ought to be won is lost? Things can go wrong in unexpected ways. And even when things go right, it can take a lot more time, cost a lot more money, and create a lot more disruption in a client's life. And so that's why in the culture of legal negotiations, the culture of lawyering, you give something and you get something. You don't get everything, and you don't give everything either. I try to avoid using the word compromise when I'm working as a mediator, because at least in the cultures where I work, the word compromise seems to be coupled with the word unprincipled or lack of principle. And I never urge anyone to do anything that's unprincipled or make a compromise. Rather, I'll talk to people about how many different principles may be at work. Yes, paying too much or receiving too little in a settlement may be a violation of a principle, but spending money in a way that on future legal fees, devoting future time in a way that your lawyer tells you may not have the same payoff, the same benefit as the money you've already spent, well, not spending money foolishly and not devoting time to things that don't really have a payoff, well, those are principles too. And so sometimes we'll talk to clients not about doing things that are against their principles, but rather identifying all of the principles that may be implicated in a particular decision and how to decide which are the most salient. Again, we're talking about the negotiation of a litigated case where the rule of law is important, and making decisions among choices in litigated cases is important. And talking about what we have in common with people in these litigated situations, and that is nobody likes to waste money or nobody likes to waste time. Those are things that we can generally discuss. Well, those are the prepared remarks that I have. And just as we've talking about lawyers in negotiations giving something and getting something, I hope I've given you something. I hope that I've given you something of value here, some things about which you can think and some things that perhaps you can put to use in the very near future, something of value to you. I hope I've given you something of value. I want to let you know you've given me something too. You've given me the opportunity to clarify my thinking and to share with you some ideas, which I hope will stimulate your thinking, again, which I hope you can put to use. I hope that these ideas will make you better mediators and better able to help other people in turn when they come to you for the valuable services that you provide. If I've been able to pay it forward or even a little bit, I've been a mediator now for 28 years. If I've been able to pay it forward even a little bit, then you've given me something of great value today as well. Thank you very much for your time and attention. I hope this has been useful to you. And if there's any additional time for questions and answers, if anything has been unclear and you'd like elaboration, if you disagree with anything, I'm happy to spend some more time chatting with you all. Thank you very much.
Thank you very much, Mr. Jeff, for that wonderful contribution and clarifying your own perspective. The participants were listening very keenly to all that you have said. We have two experts here. We have Christiana and we have Mr. Jeff on culture. Please, do you have any question that you want to ask? Let's just take a few questions and then remember we have Christiana will give you she requested for 10 minutes for you to do a practical. So any question?
Christiane, I see you all the time on LinkedIn and feel like we know each other already. If you have any questions or thoughts, I'd love to hear them.
Oh,
okay. Naive.
From me, you will not have because because everything, I'm just no comment for you. No comment. This was amazing speech. It's just one time more. I'm always attending Work for Food and another your conferences where you're doing amazing job, Jeff. And just from me, only one comment you can have it. Just take the consideration for the participant that the Jeff It's a master of his job, and he is a guru of the mediation. He had a too much good background, and he everything, but just spelling out from his. And you heard from me in the speech. You just remark in your copybook and keep it. It's a guidance.
Thank you so much.
Okay.
Truly,
All right. So
I remember
Nahid,
when I was in high school, we had a wonderful journalism teacher. His name was Gil Chesterton. I mentioned his name because he was such a wonderful teacher. And we had journalism at 8 o'clock in the morning here in Los Angeles. And you can imagine what it's like to teach a group of 15, 16, and 17-year-olds at 8 o'clock in the morning. And Mr. Chesterton would impart, he was a terrific teacher, and he imparted a lot of very valuable knowledge to us that I use to this day, the lessons that I learned from him. And he would look out at all these sleepy adolescents out there in the audience. And then from time to time, he would say, "What are your questions?" And all the, 15, 16-year-olds would be sitting here like this at 8 o'clock in the morning. And then Mr. Chesterton would say, "All right, well, what would your questions be if you had any?" So I'll ask you all, what would your questions be if you had some?
Okay, so please participate.
I guess they're frozen is some technical problems.
Me?
Nahid, please go ahead and ask your question. Your hands are
Okay,
up.
Nahid, go ahead and ask your question. Okay, Nahid. Okay, do we have any question? Any other person? Question, comment?
Yes, please.
Okay, who is speaking?
Nahid Abdullah.
Okay, go ahead.
Yes, my question is the last speaker. Thank you for an excellent presentation. The better for it. Now, I have just from your session, your class, my understanding is that you have to understand the culture of individuals who are parties to any form of alternative dispute resolution before you. Now, my question is this: have you ever had any session where you had parties from two, want to be mindful of maybe, should I use the word extreme cultural background and beliefs, and then where you could not, where you had a bit of challenge on getting them to even commence the session, and how were you able to resolve it based on their cultural differences?
So I believe the question is on convening mediations and commencing mediation sessions. To be honest with you, I don't deal with that very often, because generally in the world of litigated cases, lawyers call me or send me an email, or their assistants will call me or send me an email and say, "Hi, Jeff, we've decided it's time to mediate the case, and we've read your credentials and we'd like to hire you as our mediator." So the question of convening doesn't often come up in my practice. I think it's an interesting question and set of issues about coercing people to come to mediation. I think that someone who's coerced to come into a mediation is not likely to show up in a spirit of peace, love, and understanding, and eager to listen. And, that kind of person who's coerced to come in is more likely to come in, you know, with the arms crossed and uptight body language, and it's probably not going to be such a successful mediation. So perhaps the answer to that is that you actually have to start mediating before you think you're even mediating. So if you're talking to someone who is reluctant to come to mediation, you ask mediation type questions. You say, okay, I get it. You're reluctant to, you know, the other folks have suggested a mediation. You're reluctant to come to the mediation. What are your concerns? Right? That's a great question that we ask all the time. One of the key questions of facilitative mediation. What are your concerns? You know, what is it that I might do? You know, what is it that may seem just impossible to do? But if I could do it or say it, would make all the difference and change your attitude about coming to the mediation. I know it's something impossible, but just try me, humor me. What is it that if I could say or do it would make you change your attitude about coming to the mediation? Because you may find out some things and you may actually be able to mediate the convening of the mediation. You go back to the other side and say, hey, I spoke to so-and-so and they're reluctant to come because they're concerned about X. They think you're bringing the wrong people. What assurance can we bring them that you're actually going to have the right people at the mediation, or that you will be open-minded, or whatever it happens to be? So in terms of mediating the convening of a mediation, I tell you, as far as I'm concerned, the mediation begins as soon as I pick up the phone, as soon as the first email comes in. I am mediating. I'm mediating from the very first time I open my mouth or the very first time something hits my ears. I hope that answers your question.
Thank you very much.
Other questions? Any disagreements? Anything sound completely wrong to anybody? I'll have to think harder on that and how I can improve and refine it even more.
All right, so do we have any further question or comments? All right. In the absence of further question or comment, I would want to use this opportunity to say a big thank you to Mr. Jeff and Christiana for a wonderful, well-delivered session. We're very glad and happy that you created time out of your busy schedule to add value to these mediators in training. And it has been very, very interesting. From the comments on the chats, we have a lot of comments appreciating you all for a job well done. It has been great listening to you. You know, those are the comments we have. Thank you for this great, insightful session. It's good refresher for some of us. You know, these are all the wonderful comments that we have on the chat box. Well presented. Thank you. You know, these are them. Oh, we are happy to have you as, you know, these are all the comments, you know, from the participants. And I believe that they will connect with you on LinkedIn, reach out to you, and be happy to refer to you as someone who has contributed so much on their training. So having said so, thank you very much. Christiana, I think you can have just some minutes for them to do the practical before they go on break. Sorry, today is very hectic for the trainees.
Okay.
We hope that you get
Okay.
what you...
I'm going to sign off. Let me thank you all again. Anybody who wants to follow up,
Okay,
please
so
connect and communicate
yes,
on LinkedIn.
please, Mr. Jeff, let's have a group picture. Please put on your cameras. Let's give have a snapshot with these two great facilitators of ours.
first.
Put on your cameras quickly. Let's have a wonderful snapshot with our facilitators. We will share it on LinkedIn. We are going to join and tag Mr. Jeff and Christiana. Please do well to comment. Thank you. Wow, this is beautiful.
So we can role play just shortly
Oh.
because.
Thank you. Bye-bye.
Yeah, that's.
Thank you.
Thank
Bye.
you very
It was a pleasure to see you.
A real
Yes.
pleasure. Thank you. Bye-bye.
All right, bye.
So,
Thank you, Jeff.
dear participants, in this role play, we have to divide two parties, and you can change, take any country you want. One party represent one country, another party another country.
Christiana, do you want to break them into groups?
Better, yeah. If you want, of course, if we have time.
Or is it something you want them to do? Just choose one or two person in the joint group. How do you want it?
Yeah, how is easy for you now to join them? If somebody, we have to see who want to participate first of all. So there will be two parties.
We can, if you want it in a general group, we can pin the participants, the two of them. We pin them, or
Okay.
make them spotlight them, and then they will continue. If you want them into groups, fine. Just
no, it's okay. We can adjust. I want everybody will see. No need to go to the group. It will be much better for others.
Oh, perfect.
Participate to see how it's working. We just switch off the cameras and we just look at them how they are, except me and you. We observers, and we will see how they are playing role case. So I will shortly represent the core role plays. It's like we can the following question, the group decision. So at the end, the group decision we will have a question that can you think of a time when the culture differences affected the communication and conflict resolution in life, how cool the strategies we have discussed today, etc. Role play. We choose two countries, let them choose one and another, or if you want, I can give the countries and set up with these scenarios, and one is a mediator. After the role play, briefly with the class, we will discuss challenges arising around the culture differences. So, who you pinned? It's your decision. You can pin or they will raise the hands who want to join, and please just represent any country.
Okay, Hadiza Lawal. Okay. Who else? Please, you have to put on your camera if you're.
Yes, it's better to put because now we put, after we will switch when the role play will start. Just pin whom you know, let them start.
Good. Who else? Who else? Okay, Blessing. Okay. All right, so Blessing. All right, so here they are. These are, you have to be stable.
I'm ready,
All right.
sir.
Okay, go ahead.
So first of all, again, I want to greet the brave ones who want to participate and show everything, but I just mentioned it before in my lecture. So firstly, one is coming the mediator role, who will play mediator role, and two parties representative of the countries.
Okay, so we need one additional person. Christiana, do you need one additional person?
2 parties and 1. I guess
Okay,
Niman,
it seems to be all women.
I think Niman will be the best mediator because he understands the culture, negotiation, the strategies between Cypriots and Russians. This is good.
Okay, Nimnan, you have been voted in. All right, where is he?
And I'm very hungry now.
It's good, it's a good start.
Okay, so you have been voted, so we'll take just maybe 5 minutes thereabout, and then you can go and eat. We have to come back. We have a lot, so prepare your mind to sort out today.
Come back again.
So you have been voted as the mediator. So here we go.
Okay, let's start.
So
shortly I will explain the case. You are as a mediator, you don't know who is coming, from which culture coming to mediate. You only know there is some business issue between 2 neighbors or partners. It's like cross-culture, the business issue, but they are representative of 2 religions and 2 different cultures. This is shortly because they will just improvisate. Because if I will say about what it long,
okay, so which country are we choosing? A blessing, which country are you representing?
Okay, are we to choose now? Are you giving us the country?
Okay, Christiana, which country are you choosing for them?
So we choose. I want to represent. You can represent one. It will be Nigeria, for sure, because and another one we will choose United Arab Emirates.
Okay.
Okay, who represents Nigeria and which other country?
Okay, I will represent the United Emirates, sir.
Okay, Nigeria. Then Arab. Okay, where is the other person? Okay, we now have okay, we have one spotlight. Okay. Then we have, where is Blessing? Blessing. Okay, it seems you are going to replace Blessing. She's no more. Maybe she has a bit. Okay, so okay, I saw Pushi raise her hand initially. Are you available?
Okay, very good.
Yes, sir. Yes,
okay,
sir.
Okay, all right. So here we go. You have to put on your camera. All right.
So I will ask all participants switch off cameras. You just will attend, and the mediator and the parties. Let's start. You improvisate. Everything what come to your mind. You have to now play a role like it's really coming closer to your nature. Use your nature, use your religion aspect, your culture, everything what you want to show. Be individual, okay? So we want to see really cultures aspects. And they good luck to mediator.
Okay, ma'am.
Okay. Unfortunately, I've not seen the other party. My name is, you're welcome to this arbitration. My name is Nimna Denda. Sorry, are you hearing me?
Yes, go ahead.
Okay, it's just that I'm not seeing the other party because this.
Oh, don't worry, you are going to see them now. I'm going to add them to the spotlight. That is
I'm seeing Hadiza. It's only Hadiza that I'm seeing.
who's she? Where is okay, she's spotlighted. Why you two should be spotlighted? What is spotlight? Yes. Okay. Yes. Then who's she? Where is Christian? All right, please put on your camera. All right, go ahead.
My camera is on.
All right, go ahead.
Okay. Good afternoon, all. My name is Nimna Denden. My office is number 2, 3A Secretariat Road, Jos. I'm happy to have you. I'm happy to mediate. I'm happy to be here as a mediator regarding your issues. Thank God that the two parties have signed the mediation agreement, and just
The
assuring
network
you,
got me.
just assuring
Hello?
you. Hello, I'm hearing you.
So I have a business. I want to supply palm oil to your country, and we have it in quantity. So I want the supply that we made. I have the payment. I'll send money to them, and then the what I sent up to now, I've not heard from them. They have refused to send back my money. So, and I think the best thing is to get you to mediate, see how my money can. Yes, please.
Sorry, you know, when you went out, we chose another, some people were chosen. So please,
Sorry. Okay.
yes, and sorry,
the
just
network.
so
Okay,
sorry.
so
let them, we chose someone to replace you before you came in. So please let them proceed and hope that we don't have issue with network. So, Mr. Nina, please go ahead, please, quickly.
Yes, thank you so much. And as the two of you are aware, the two parties are aware this meeting is by Zoom. Can I assure you that I'm a neutral person? And as two of you are aware, this mediation was referred to us by the settlement house. Let me just keep those ones, please. Now, can you introduce yourself, please? Can we start with the plaintiff, Hadiza?
Yes, sir. Assalamu alaikum. Good afternoon. I am Hadiza Law. I took this case to court, and the court referred us to the settlement house to settle this case. So I have an issue. I and my neighbor put in money together to rent an area so that we can be doing hair service for women. But I'm having issue with my neighbor and my partner because she keeps on bringing men, which for me, it's not, it's like for my religion, we are not allowed to be in the same room with men that are not our Muharram. But my partner keeps allowing men to come in, even though we have discussed this before we started the business, sir. So I'm here hoping that we'll be able to solve this case, sir.
Okay. Thank you so much. Can we hear from, is it Kushi? Who is the second? Can we hear, Kushi, can we hear from you? Need your opening statement, please. Mr. Hanchan, can you join us with the second person, please?
Good afternoon.
Good
Good
afternoon.
afternoon. My name is Kushi Grace Saidu. I'm a Nigerian, and the dispute between me and Hadiza, we could not agree due to our differences, cultural differences, and we were advised to come for settlement in the settlement house, and I wish that this mediation that you are going to do between the two of us will be able to make every one of us be satisfied. Thank you very much.
Welcome. Yes. Like I've already told you the rules of the game. This is a matter that I'll prefer to have caucuses with you. Let me speak to Adiza differently, and then I'll come to you differently as well too.
Okay, sir.
Adiza.
Okay. Yes, sir.
Yes. We're going to speak confidentially. Whatever I'm discussing with you here, she's not going to hear it. But as a Muslim, I know that just like you said, bringing a man into your house is against your culture. And as a Christian, from our own side, she said bringing a man into the compound is not a problem to her. Can't you give us can I have an idea? How do you want this issue to be resolved?
As you already know, as I've said, only for us Muslims, only our Muharrams are allowed to see us in our own house. And people that are my neighbors and our colleagues are not my Muharram. So what I want or what I expect from this is maybe for her to give me notice before someone can come in so that I'll be properly dressed, or maybe be in a proper manner. Or maybe when she wants to meet this male friends or relatives, maybe she can take it outside of the house. This is what I'm hoping to resolve today, sir.
Thank you so much. Please, can you give me 2 minutes? Can I talk to Ruski? I'll come back.
Yes. No problem, sir. Thank you.
Okay. Mr. Nanchan, can I go back to Ruski?
Yes, please.
Udi, okay. Yes, Udi. Are you there? Hello? Hello? Ushi. Hello, Ushi.
Please unmute, Kushi.
Hello,
Kushi. Okay, is Blessing here?
I'm here.
Okay, please, they are talking.
Okay, Blessing, you are taking the position of Wushi. So we are having
Okay,
a caucus meeting with you. This discussion I'm having with you is confidential. Can I find out from you? Is it okay? How bad would it be for you if you have a male friend that wants to visit you, for you to give notice to your colleague that you're staying within the house before your male friend would come? Is it going to be difficult for you?
Well, it will not be too difficult for me. It will not be too difficult for me.
Okay. So, will this, assuming your colleague now insists on you giving her 3 hours notice before your male colleague would visit, and maybe the male colleague should stay outside for you to receive him, would that be too difficult, or would that be too uncomfortable for you?
No, that will not be too uncomfortable for me. It will be okay if I agree to that. If that will bring peace, then I will concede to it.
Okay.
If that brings a peaceful agreement, if she will concur to that, then it will be okay for me. I think I can concede to that.
Okay. All right. Thank you so much. I'll be taking the 2 of you back to the common house, the room, so that we can meet the 2 of us. So can I have Hadiza as well too, please?
Yes, they are all here.
All right. Thank you so much. Yes. The 2 of us, the 2 of you are here with me now. Can I put it this way? The 2 of you are staying in the same house right now. Can I put it this way? Is it okay that anytime a visitor is coming, if we can have an agreement like this? No, sorry. Now that the 2 of you are around here, can I ask Hadiza again?
Yes, sir.
If assuming Blessing has agreed that before a visitor would come, they would take you into consideration, how many hours, let's agree between you and Blessing, can the 2 of you discuss how many hours notice should it be given to both parties before any male visitor would visit any of you? Can you people discuss among yourselves?
Yes, we can do that, sir.
Okay.
As we spoke earlier before we came here, for me,
no, sorry.
Yes,
Don't make
sir.
any reference to my discussion with you. This one is
No,
discussion
sir, I'm
between
not
the 2 of
talking
you.
to reference to you. It's a discussion I had with Blessing at home, the argument we have. Yes, sir. During our argument, she was like, she's staying in the same house, we are paying the same rent, so she doesn't need to give me notice. But I just want her to consider me.
Sorry, Hadiza.
Yes.
You know,
Yes,
you're
sir.
directing the discussion to Blessing, not me, or to a third party.
Oh, okay. Sorry,
Yes, the 2 of you are in the same
Okay.
room now. You're discussing to each other.
Yes, Ms.
I want the
I
two
know
of
we
you
have.
to have an amicable settlement regarding how you want that issue to be handled.
Okay. I know it's not easy for me, and it's not also easy for you, Ms. Blessing. So I'm hoping maybe if you can give me a notice, let's say an hour or two notice before you invite anyone in. And being considerate to you, I will do the same thing if I also want to have someone visit. Is that okay with you, Ms. Blessing?
Okay, if we let's agree that both of us will give each other 2 hours notice before any male visitor will come. So I'll put ourselves in perspective. Is that okay for both of us? So then
Yes,
we
I think
agree.
it's okay for us. Yes.
No.
Okay, then we can
Don't forget, you offer 1 hour. She's saying, Blessing is saying 2 hours. So can
I
we?
gave her a variety of an hour to 2, sir. So
Yes, but
since
she's
she's
giving
okay with 2,
yes.
okay, and I'm okay with 2 hours time, sir. It will give me enough time to get out of her hair. Miss
So,
Blessing,
okay.
if 2 hours is also
All right.
okay by you,
okay by me.
Okay. So can we draft, can the two of you write that agreement down by yourselves?
All right, thank you very much. Congratulations, you have done well. So, Christian, over to you. Okay, so
can we unmute now, sir?
I think I will interrupt the participants. I know it will take its long story. I want to conclude. Behalf of our organizers, I will take a floor, and I want to all of you switch on the cameras, please, and we will discuss. I do believe the technical issue is too much important. In OEDR, dear participants, especially for the mediator, to have a clear network, good network, is a half winning case, because that time in the cultural aspect, you can see it, you can read the eyes, you can see the gestures, you can have eye contact correct, which I want to see the second participant. I could not see except United Arab Emirates today. And I will say that one thing she did not correct, but she's a participant. She's showing you as a mediator, Niman, how she is at home, how she's acting. She's not a business lady, because the business women, she will act a bit different. I want to be honest with you. The business women's most of the time, because they know how to act in a business. But here is a different level. This is some misunderstanding between some concept, the dress code, and it's more a religion aspect in the cultural diversity. Everybody hear what I'm telling?
Yes, ma'am.
Perfect. So for the mediator, this case was difficult. And I look at the Niman face and understood he tries to find the way how to communicate, what kind of correct question to ask, you know. But you know why it was difficult for you? It was difficult for you because them they was not speaking. They didn't open the speech. They didn't say about their really the position and their problems. It was not brainstorming. There was not a correct presentation. And it was not easy for you. Yeah.
That's right.
So it was I helped you a bit, but look at the ISIS. As a psychology, I will say that from United Arab Emirates, she felt herself not comfortable. It was not eye contact. She was hiding something. Actually, it was not maybe not an issue. Maybe she get just have a principle to come with agreement or come to the mediation in order to scream about herself, in order to show, yes, I want to do what I want to do. But there, maybe I'm wrong, but maybe other party compromise her. So he had some issue. Your point as a mediator, figure out. This is a problem. This is a difficulties to be a polyculture mediator. You are doing all jobs at the same time. You are going between lines. You want to understand. You are a psychology. You are everything. You have to learn the cultures. You have to know the differences, nuances of the dialects, timbre of voice. You have to hear. Oh my God, this woman is under depression. This woman don't lose. She already lose interest. She dropped his eyes and she just lose interest in order to communicate. Actually, she didn't came to mediate because these gestures show the screams for you as a mediator, and in order to take there, that's why I said I gave you tips before to drive and just jump to negotiation. Take it easy. Have a coffee break, small talk, in order to take their attention.
Okay.
It's different, my dears. It's a culture mediation. It's different. You can't dive and jump in a negotiation because you have to give me 10,000 euro. I have to give you this because we have a business. You have a petrol station. I have this. This is different. This is too much nuanced and too much difficult mediation.
That's correct.
So it was a pleasure to see all of you. I want to thank organizers, and I want to wish you good luck in your future with your future lecturers. And at the end, I will know if you need my help. If you have questions, please, anytime I'm free. You know, the organizer will share my LinkedIn links, and if you have any issue, just I am free to contact and answer on all questions.
Thank you very much. Thank you very much, Christiana, for creating time to be with us. The participants are very grateful. Okay, Adiza, you have a question?
Yes, sir, I do.
Right.
Thank you very much. Thank you very much, Ma, for this insightful presentation. I have a question. You were saying to the mediator that he was quick to reach to start negotiating or find solutions to an agreement. How fast or how soon should the mediator start looking for solutions or start asking questions in a pursuit to solve the conflict? Am I phrasing it right?
Okay.
How soon should he drop observing the parties and start looking for solutions?
In cultural mediation, is no timing, as I mentioned before, because you don't know with whom you actually dealing with. What kind of background? That's why I wanted to mention, this is a pencil example. You don't know who made this pencil, from which country this pencil has. This pencil has his history. How you can get this history by like the we have a legal frame. Okay, so mediation competition. 5 minutes for this, 10 minutes from the presentation, 15 minutes for that, and feedback 10, 10, 10, 10. No way. In reality, my dears, it's not working in this way. It's not working. We are a human being. We have emotions. Just imagine, you just role play because it's not touch your really heart. It's not touch your how family. It's not touching your babies. It's not touching your business. It's not touching your money. But imagine everything in one. You will react different. You will see the mediator will see the tears, screams. You will see everything, and he has to be sure that you are a decision maker, especially in the business. You are a decision maker. It's time to small talk. Sometimes a mediator taking this break in order to understand, oh my God, I have to see it. This is true religion. Okay, I have to, oh, this is Muslim. So 12:30, he have to pray. Now 11:15. Do maybe it will run over 1 hour or 1 hour 15 minutes. I have to. He is control. He is just a commander. He have to control the timing of some nuances in religion and culture. But to solve is endless. I'm not telling you from the 24 hours you will handle the case. No, he can divide the session, and it's no just it's not a movie. No movie. We are not playing we are universal soldiers and we save planet from the aliens in 24 hours. No, it's not a movie. This is reality. This is reality. We are taking off the ice glasses, the rose pink ice glasses, to see the beautiful life. No, you don't know with who you are dealing with. They can send you settlement brief about the case from the lawyer, we have a brief about the case as a mediator, but sometimes no. But that's why I advise you to have pre-mediation before to come to mediation, especially in the culture differences. Pre-mediation. You can have a break. You just can find some answer questions, and you facilitate the time. You have you are flexible, and you understand that. Okay, now I know with who I'm dealing, and you will make decision. And next day, when you get appointed session, you will understand Khadija. Oh, she have a really hard character. She don't like, she react on this question, she disreact, and she's direct, he's indirect, and the mediator have to be ready for everything. Or she's Jewish, or no, Saturday we will not meet, even though we have next session, and because the part is Christian, for her is Saturday is okay, but Sunday no. Oh no, he's Muslim, Friday we can't. Especially everybody going to mosque or they're praying. So these nuances is too much.
Yes, ma. Thank you very much, ma. Please, another question on it. Okay, I understand. In reality, we all have different personalities, and we come in with them. So let's say, for example, in this scenario that you just give us right now, I am an Arab woman. I was being timid, not speaking out loud, not even becoming strong with a big personality. So in most cases, Ms. Blessing will be able to communicate herself, be able to communicate more than I will be able to. So do I, as a mediator, do I have to do I have to wait or push Mrs. Hadiza from looking that she's mild, that she's not speaking, or do I just go ahead and continue mediating?
In mediation, we are not pushing nobody. In mediation,
oh, sorry, not pushing is the wrong word. Sorry, ma'am. Sorry, I'm at a loss of a word to use. Pushing is not what we do as mediator, but maybe oh yeah, let me.
I understand.
I'm sorry, I don't know if you got what I'm
I
saying.
will answer because I read people. I am a profiler. I know what you want to say to me. You want to understand how to take out and pursue it from them, to pursue the way to active questions, after active question, to direct dialogue, to open their mouths in order to have answers on your question, to understand the really issue, to write down the agenda. Because without agenda, without knowing this, you can't handle any case. I will tell you something. That's why in premediation, always go to premediation. If the mouth is not opening in premediation, you will be ready. Okay, I'm using different mediation technique. We have different mediation technique for mediation style. So with hard people, you can go from the beginning focus. You can go not use traditional mediation style, especially in this with kind of hard parties. We are going straight to the cause, like did Naman, and he did because he didn't know the nuances between you. You can go and facilitate. You can meet one by one. And in a private, actually, face-to-face, the people more open than in the groups, because we are different psychotypes. Somebody is introvert, somebody is extrovert, somebody is different. We have 7 psychotypes of people, and we, the mediator, as a polyculture, have to know psychology like a second science. So in order to date and understand the people, we have to learn. But actually, nowadays, the all mediation certification courses, they take a bit tips from the psychology, which is not, for me as a psychologist, not good, because as a culture mediator, we are using a lot of tools from the psychology. Without knowing this, is not easy to learn. Some of the countries will not even accept you as a mediator if you don't have degree in psychology, like in Greece, like in Cyprus. You will never handle family case if you don't have degree in psychology. So different countries, they have different requirements. But for all, I'm writing now my book, and I do hope we'll finish soon, about exactly tools how the people have to use from different geographic countries, and their polyculture is one. Actually, I want to finalize and understand. We, as a human being, 2 hands, 2 legs, and 1 head, we are all one. We have the same emotions. We have the same feelings. We're not dividing by race, color, nationality, religion. We are a human being, but feelings, emotions, we have same. Religion, nationalities, geographic, the location, or everything. Only this can be divided. It's separate. We can separate people, but as the stage says, and I like it, everything you can replace except culture. Everything around you can replace except culture. You was born with this culture and you will die with this culture. This is how it is. And I want to thank all of you. I do believe I answered on all of your questions. If you have any questions, you know how to contact with me.
All right. Thank you. Thank you. Thank you. We can't thank you enough. It has been a wonderful time. We appreciate you. Please, can you put on your cameras so that we can have a last snapshot? Put on your cameras.
And release it from your side, sir.
Let's put on our cameras.
Hello, sir. He said the camera
All
was
right.
disabled by the host.
Okay. So this is fine. Everybody's camera is on. Okay. Okay. All right. Thank you very much. Thank you.
Thank you very much and good luck to all of you.
Yes, and goodbye. Okay, thank you. Thank you. Yes, thank you. All right. We have had a very long day today. So let me find out. Do we stop here and return tomorrow morning around 8? Or we'll take a break and come back?
We'll close now, sir.
Pardon?
Let's close now. Tomorrow we'll resume by 8.
No, let us all agree so that we know that we are
It's
coming
9
back.
a.m. 9 a.m.
Let's close now, sir. So tomorrow by 8.
We're able to do it.
No, it is early, but I don't know. Unless we are
Let's
finishing.
have a virtual hand, and then I'm going to be the president of the National Assembly. Once I just say the 8th habit, that is it. So let's see. Those for 8:30, can you raise your virtual hand? Raise your virtual hand. 8:30. Okay, Olua. Olua said yes. 8:30. Jen Marie, 8:30. Jen Marie, 8:30. Kushi, 8:30. Maren, 8:30. No, Maren is not 8:30. Adeumi. Okay, 8:30. We have 1, 2, 3, 4. I think it's 5. 8:30. 5. Okay. Those for 9 p.m.
PM or AM?
AM.
9 a.m.
Sorry, is it 9 a.m.?
Yes.
No, we said 8:30.
Is it AM or PM?
AM. AM. Okay. This one, Blessing, Stephen, Nimnan, Maren, Eddie. Oh, okay. 8:30, 9 o'clock. Okay, Gitik at 9 o'clock. So see, now you just need to good. We're trying to see how we can ensure that you get all that you need. And then time is not on our side. We have a lot of things we need to pass across to you so that you can have value. We can just say, yes, we are done. We close the session, everybody goes. And then, you know, at the end of it, maybe there is one or two things. There are one or two things that you've not gotten. So it is all for your interest. We want to come. If we come that early, we are going to start. Okay, so what we are going to do is we are going to start we are going to start if you're able to join, fine. But before 9 o'clock, we are going to commence our activities properly so that we can do one or two things before the time. So 8:30, we are going to start with check-in activities so that by 9 we are concluding, we can do some of the things we have scheduled and we're not able to cover up at 9. So but if you can join by 8:30 for the check-in activities, we really appreciate. Is that okay?
That's okay.
It's okay.
Right. Thank you.
Thank you, sir.
Thank you so much.